Name of Mr. Name of Deputy Solicitor General of India may be reflected
Yes.
as the counsel for the applicant in the cause list henceforth.
Fine. Lordship, with the consent of the other side, Lordship, I am mentioning the item number 25 and 30, Lordship. The matter may be passed forward to the Lordship. Item number 25 and 30.
Heard Mr. A. Kakoti, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the other side regarding his 31 you have informed.
Inform, Lordship.
Your Lordship, in this matter, I'm appearing on behalf of respondent number 1, 2, 3, 4. So date may be fixed on 26 or 28.
The prayer is allowed. Let this matter be listed after
26 or 28.
no 2 weeks on a date to be fixed by registry. Yes.
My pleasure, Lordship. For listing of an IS civil for early hearing, can it be on Monday, Lordship?
Okay.
Orders with
Okay.
Lordship, I am again mentioning the item number 6, Lordship. In this item, Lordship, we are filing objection, Lordship. It's today itself. So it is not listed in the part of the record, Lordship.
You have informed the other side.
Yes, Lordship, I am
Heard Mr. A.R. Agarwal, learned counsel for the applicant. Also heard Mr. A. Kakoti, learned counsel for respondent number 1, who submits that respondent number 1 has filed an objection against the prayer of the interlocutory prayer of the applicant. However, said objection is not on record. He therefore requests.
Today they are going to be filed.
Today itself, Lordship.
Not filed.
Oh, he submits that the respondent number 1 would be filing written objection during the course of the day and hence prays for an adjournment on that ground. Prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Lordship, I beg to mention item number 19, Your Lordship. In this case, the arguing counsel, Mr. S.P. Roy, is a personal bereavement in the family, Your Lordship. The state is the opposite party, Your Lordship. And we fix on next Thursday.
Item number
19, Your Lordship.
19.
Maybe it fix on next Thursday.
What is your name?
J. Das.
Heard Mr. J. Das, learned counsel for the appellant, who submits that there is a bereavement in the family of
Mr. S.P. Roy.
Mr. S.P. Roy, the learned counsel for the appellant, and hence an adjournment is prayed for. He submits that he has informed the Mr. Gogoi, you don't have, Mr. T.R. Gogoi, learned government advocate, does not oppose the prayer, hence the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Like, Your Lordship.
May please, Your Lordship. Lord, I beg to mention item number 8. I have obtained the consent of the other side. In this case, my lord, I need to file affidavit in opposition.
8.
My lord, 8.
What?
8, only 8.
Heard Mr. M. Islam, learned counsel for the respondent number 1 and 2, who prays for some time for filing written objection against the interlocutory application filed by the applicant. He submits that he has informed learned counsel for the applicant regarding his prayer for adjournment, who does not have any objection. Hence, the prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
May I?
Highly obliged, Your
I
Lordship.
beg to mention item number 7, Your Honor. Kindly assume this matter for the day, and this matter may be come up after.
You're for?
Your petitioner, Your Honor, on behalf of P.S. Razai.
You have informed the other side.
Yes, sir. Yes, sir.
Prayed on behalf of my senior sir.
Heard Mr.
A high.
A. Halim,
A high.
A. High, appearing on behalf of Mr. P.S. Raza, learned counsel for the applicant, who prays for an adjournment on the ground of personal difficulty. Learned counsel for the respondent does not oppose to the prayer. Hence, same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry. No. After a week on a date to be fixed by registry.
Bless you.
May it please your lordship. Lordship, I recommend item number 33 with consent of other side lordship. It's the supplementary list lordship. In orders column.
Yes.
Lordship, I recommend that this matter maybe come after 3 weeks. Lordship, I have to file an objection in IA lordship. They have filed.
What is your name?
K Islam.
I am for a petition.
Heard Mr. Zaid Muki, learned counsel for the petitioner. Also heard Mr. K. Islam, learned counsel for the respondent, who prays for an adjournment. Why you are seeking adjournment?
I have to file written objection in IA.
Or filing written objection against the interlocutory application filed by the petitioner. The prayer is not opposed to by the learned counsel for the petitioner. Hence, same is allowed. Let this matter be listed after a week on a date to be fixed by registry.
3 weeks lordship.
After 3 weeks on a date to be fixed by registry.
Obliged.
May it please your lordship. Your lordship, I'd like to mention the listing of an MSc appeal for hearing next Thursday.
Hearing, it will not come by mentioning.
Your lordship, we've given repeated applications to the registry, but still it has not been listed.
You file a interlocutory application for expeditious hearing. You file an IA.
May it please your lordship, I'd like to mention listing of the MFF in orders column, my lord, next week, my lord.
Okay.
Much okay.
May I please, lordship, similar prayer. Next week, any day.
Okay. Next week.
I'm so blessed.
Clear hearing, item number 2.
Yeah, please, your lordship. Lordship, conducting council is on late. Matter may pass over for timely.
What is the matter?
Lordship, it's the NDPS case. You earlier rejected.
Okay, let him come.
Orders item number 1.
May I please, your lordship? Lordship, I am appearing on behalf of Mr. A.
Number 1 admission.
Okay, sir.
Yes.
I am appearing on behalf of Mr. A. Bhattacharya, lordship. We have some difficulty today. The kindly pass over the matter for the day. He just informed me over phone.
Okay.
Any date may be fixed, my lord.
Heard Mr.
A. Borua.
A. Borua, learned counsel. A. Borua.
A. Borua.
A. Borua, learned counsel, appearing on behalf of Mr. A. Bhattacharya, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also heard Mr. K. Borua, learned counsel for respondent number 1, who does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed. Date at the 9th of June.
How long, my lord? Can it be possible in the next week? Because, my lord, award was granted in my favor, my lord, and he is insurance man.
9th of June.
Okay, right.
Right, my lord.
Item number 3.
May I please your lordship?
Yes.
In this case, service is already completed and LCR also received. It made a case list for hearing.
Ready for hearing?
Yeah.
What is your name?
P. Sharma.
Heard Miss P. Sharma, learned counsel for the appellant. Also heard Mr. S. Das, appearing for respondent number, all the respondent number 1 to 5. It appears that this matter is ready for hearing. Accordingly, list the same for hearing on 4th of August.
Lordship, IA of 2320 is this case.
At the time of hearing, we will dispose of.
Item number
Complex.
4.
Problem.
May I please, Your Lordship? Lordship, kindly call for time being, Lordship.
Yes, what is your prayer?
Time being, Lordship.
What time being?
My senior is appeared for another. Point time.
Okay, we'll take it up after some time.
Item number 9.
Lordship, this is a delay convention petition. Lordship, respondent number 1 has appeared, and in respect of 2 and 3, service report is awaited. As per business dated 11/5.
Queen 3 will direct the registry to place postal track consignment. Heard Mr. A.J. Swekya, learned counsel for the applicant. Also heard Mr. M.H. Ahmed, appearing for respondent number 1. Office note dated 11/5/2026 shows that the notices issued to respondent number 2 and 3 have not yet returned. Stop. The registry is directed to place the postal track consignment report of notices issued to respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed. June. 11 June.
Item number 10.
This application is for delay condemnation. Delay is only 204 days.
How many days?
204 days.
Even it is for the prolonged illness of the petition.
You are opposing.
No, Lordship.
You are not objecting. Heard Mr. F.Z. Mazumdar, learned counsel for the applicant. Also heard Ms. D. Goswami,
Or respondent.
appearing for the sole respondent. This you have made only one person.
Only one person is there in the original. Yes,
MSc application also.
in the MSc case, there is only one person that's prepared.
Okay. Appearing for the sole respondent. This interlocutory application has been filed by the applicant under Section 5 of the Limitation Act 1963, praying for condonation of 204 days in preferring the connected MAC appeal, wherein the judgment and order dated 15/2/2025 passed by the Motor Accident Claims Tribunal number 2, Hailakandi, in MAC case number 13/2022 has been impugned. The applicant has stated the reason of delay in paragraph number 3 3 and 4 of the instant interlocutory application. Stop. Considering the reasons shown by the applicant, the learned counsel for respondent has not opposed the prayer for condonation of delay. Stop. It appears that the applicant has stated that due to severe ailment with which the applicant was suffering, male or female,
Male.
he could not file the connected appeal within the prescribed period of limitation. Stop. Considering the grounds stated in the interlocutory application to be sufficient cause which prevented the applicant from filing the connected appeal within the prescribed period of limitation, the delay of 204 days in preferring the connected appeal is hereby condoned, and this interlocutory application is accordingly allowed. The registry is directed to register the connected appeal and list the same for hearing, list the same for admission after a week on a date to be fixed by it.
Petitioner is bedridden condition, so date was fixed.
After a week, within next week, on any date will be fixed by registry.
Saying that date was fixed.
List this matter in the next week on a date to be fixed by registry.
Right.
Item 11.
Please, Your Lordship. In this case, the trial court records have been received and services also complete. So matter may go for hearing.
Heard Mr.
Yes, they can.
B.S. Dekar, learned counsel for the appellant. Also heard Mr. T.R. Gogoi, learned government counsel appearing for respondent number 6 and 7. Also heard Mr. R. Sharma, appearing for respondent number 1 to 5. The appearance of party, the service of notice to all the respondents is complete. It also appears that the trial court records have also been received. Hence, this appeal is ready for hearing. Let this matter be listed for hearing on 6th of August.
Item 12.
Your Lordship, as per office note dated 11/5/26, it is mentioned that steps not taken, but we have taken just recently, Lordship, on 11/5/26.
But Miss
Lordship, I have IA Lordship 1077 of 26. Lordship, I am praying for release of the whole amount. Lordship. There is no stay on the bill.
stays there.
No.
We have a petition, stay petition. That is 1098.
Copy has not been served, Lordship.
Just a minute. Heard Miss Adi Majumdar, learned counsel for the appellant. Also heard Mr. M.K. Nyog,
SK Singh.
SP Sinha,
SK Singh.
SK Sinha, appearing for respondent number 1 and 2. Though the office note shows that no steps for issuance of notice on respondent number 3 and 4 have been taken, however, learned counsel for the appellant submits that the appellant has recently taken steps for issuance of notice, and hence she prays for awaiting the service report in respect of the said respondent. The prayer is allowed. Let this matter be listed again on June.
Lordship, I may be.
Just a minute. Just a minute. I am coming to IA. 24th June. Yes, what is the IA?
Lordship, in the IA, Lordship, I am praying for release of the awarded amount.
Which IA?
Lordship, 1077 of 2020.
But are you praying for stay?
Because Lordship, it is policy condition. There was no policy for the passengers. That is our appeal.
In that event also, Lordship, Supreme Court says, Lordship, under the principle of.
No, are
pay
you
every
pressing
cost-
for pay? So pressing for your stay application.
We did not press earlier also, Lordship, when it was.
You are
when we
not
did-
pressing for stay. Then you go for 100% before the tribunal.
I'm praying for release of the entire amount, Lordship, in this
No,
application.
they have to go for
There
execution.
is
Then
no
Lord-
stay. They are not pressing for stay.
Then Lordship may give an observation, then otherwise, Lordship, as the appeal is pending here, Lordship, they may not.
No, observation is not required. Pendency of appeal in itself does not operate as stay unless stay is granted.
The appeal is pending, Lordship, they may not consider my appeal. That's why I'm opposed this process. One
Which is your interlocutor?
If any observation, we have a right to object to that, Lordship. How can they file a petition?
No, I'm dismissing this
Yes.
with the observation that they may go for execution.
That observation,
that's-
that
Is,
observation, in fact, not necessary
not
because
necessary.
174 is there, Lordship.
Not necessary.
I'll pray that that observation may not be given.
It may be given otherwise.
Heard Mr. S.K. Sinha, learned counsel for the applicant. This is IA number 1077/2026. Also heard Ms. R.D. Majumdar, learned counsel for the respondent insurance company. This interlocutory application has been filed by the applicant/claimant praying for a direction to respondent insurance company for depositing the entire awarded amount before the registry of this court and release the same to the applicant/respondent. Staff.
They have made the owner and driver party, notice is not sent to them because they are necessary here.
No, we are dismissing this because you are not pressing stay
Yes.
on that ground. Learned counsel, Ms. Hardi Majumdar, learned counsel for the respondent, respondent number 1 insurance company, has submitted that though the insurance company has filed an interlocutory application, that is IA number 1098/2026, praying for stay of the execution of the impugned judgment and award. However, the insurance company is presently not pressing for the said stay application. Under such circumstances, there is no bar for the claimant applicant for going for execution of the impugned judgment and award before the executing court. And hence, this interlocutory application is not maintainable at this stage. This interlocutory application is accordingly disposed of.
Disposed or dismissed?
Disposed of. Meaning has to be ascertained from the previous observation.
Let's. I'll have that.
Item 13.
My pleasure. This IA has been filed seeking return of an exhibit.
Return of the?
An exhibit in the original case.
It is a disposed of case.
No, my lord, it's a pending case. Appeal is pending. But however, on the last occasion, we examined the record and the original is not there. So
You are seeking original PPO.
yes, my lord.
which is not there in record.
In record, which is not.
Then
I will-
this application is,
Yes,
you are
it is in front of
withdrawing.
us. Yes, I am withdrawing.
Heard Mr. O. Laskar, learned counsel for the applicant. I also heard Ms. A. Bayani, learned counsel representing the insurance company. Learned counsel for the applicant submits that though this interlocutory application has been filed by the applicant praying for return of the original pension payment order, which was exhibited as Exhibit 6 before the Motor Accident Claims Tribunal, however, he submits that on inspection of the records which is available before this court, the original pension payment order is not found therein. Therefore, he submits that the applicant is not pressing the instant interlocutory application. Stop. Accordingly, this interlocutory application is dismissed on not being pressed.
The appeal is, my lord, this is a 2013 appeal.
When you want hearing, it is ready for hearing.
Yes, it's ready for it.
Heard Miss A. Bayani, learned counsel for the appellant. Also heard Mr. O. Laskar, learned counsel for respondent.
1 to 4.
1 to 4. This appeal is ready for hearing. Let this matter be listed. No, no. June 23rd, Samson. June 23rd.
Item number 32, again.
Oh, Anna.
Lordship, may please, your Lordship. Lordship,
Yes.
I have to all the respondents here, Lordship. TC was, as per the last office note dated 12/5/26, Lordship. TCR was called for, your Lordship. It has not been received yet.
Right. Yeah, para 8.
Ramesh, into the separate file of separate file on monitor kori. Otherwise,
Please. So the injunction appeal minor. An injunction was granted by the trial court against which you came. Appeal was admitted on 20th of March 2026. Order was passed in the appeal itself.
okay. Heard Mr. D. Mujumdar, learned senior counsel assisted by Mr. H. D. Chaudhary, learned counsel for the appellant. Also heard Mr. G.
S areas, Lordship.
S. Areas appearing for respondent number 2 and 3. Who is appearing for 1?
So, Lordship, we are only appearing, Lordship.
Appearing for all the respondent. On perusal of the office note dated 2/5/2026, it appears that the records of the trial court have scanned copy of the records of the trial court have not yet been received. Registry shall issue reminder for the same.
Okay.
Let this matter be listed again on
20 July.
20 July. The interim order granted earlier shall continue. till
Lordship,
next.
humble prayer, Lordship. Can it be on first week of June? Any hearing, your lordship?
The records are yet to be.
First week, not possible.
Lordship.
20 June.
Deeply obliged.
কি হল 20 জুন বুলি কৈছে আপুনি
Stamping item 2.
May I please, your lordship? Lordship, this is subsequent second application, lordship. Regular bill, lordship.
yes
Subsequent second application, lordship.
where is the first rejection order
It's on page 61, lordship. There, earlier, lordship, the petitioner has taken ground that there are two separate seizure lists, and they have taken the ground that the separate seizure list may be taken separately, and that grounds, lordship has rejected their plea, lordship.
now what is your plea
Now,
And then the 2 times rejected, Lord.
no, between both the petitioner has filed separately.
Okay.
And lordship, now I am taking the ground of violation of Article 22(2), Clause 2, lordship, for illegal detention, lordship. Regarding that, lordship, my plea is on para 9, lordship, in my petition, and lordship may first come to page 25 of FIR, lordship, where the physical custody of the petitioner, when it was taken, it has been mentioned, lordship. In the very first paragraph of the FIR, may I read, lordship? Page 25, lordship.
yes yes
With reference to the subject cited above, I have the honor to report that today, on 2/4/25 at 7:20 AM, lordship, ASI so-and-so, Gauhati GRPS reported through a phone call via above noted GD reference that today during a checking conducted by him, along with the train checking team, along with Gauhati GRPS on train number so-and-so, train so-and-so, after its arrival at the around 6:55 AM at platform number 1 of Gauhati railway station, they recovered huge contraband of suspected cannabis, ganja of 1 trolley bag and 1 luggage bag from the possession of 2 passengers who were sitting together on seat berth number so-and-so of coach so-and-so of the aforesaid train. Lordship, the physical custody of both the petitioners in this case were taken on 7:20 AM on 2/4
from where you are saying
from the FIR.
it does not say that custody
Information is.
it is
No, Lordship, they have, in the very first para, they have mentioned they recovered huge contraband on the very first.
yes it is only regarding recovery it is not regarding detention
Yes. After that, also the seizure list, lordship. They have, lordship may come to the seizure list, lordship, which is on page 26, lordship. Date and time of seizure is there from the accused person.
yes
Lordship, from the petitioner number 1, the date and time of seizure is 8:27 AM on 2/4/2025. And lordship, from the petitioner number 2, the date and time of seizure is 9:05 AM on 2/4/25, lordship.
where is the petitioner number 2
Petitioner number 2's lordship seizure list is on page 29, lordship.
Yes.
So type 29 is the type copy and the vernacular, the relevant one is on page 30 Lordship.
Yes.
Therefore,
Now, what is the submission?
now they have been produced beyond 24 hours. As because Lordship, we have annexed the medical prescription record of the petitioner number 1 and petitioner number 2, which Lordship will find on page 55 and 56. Page 55 and 56 of both petitioner number 1 and petitioner number 2. Lordship, there is a column where the date and time before production was made, the medical of the petitioners were conducted, Lordship. Medical examination were conducted. And that date and time of registration, it's mentioned as 3/4/25, 10:59 AM. And after that, Lordship, of petitioner number 2, 3/4/25, 11 AM, Lordship. After that, they have been produced before the court, which is beyond 24 hours, Lordship.
What is the time of your arrest?
Time of arrest, Lordship, that physical custody where my submission is that physical custody was taken on as per the FIR, which is mentioned on 7:20 AM itself.
No, FIR does not mention about taking physical custody. On what basis you are saying?
Date and time of arrest, Lordship, as per the forwarding, Lordship,
Where is the arrest memo?
arrest memo is there, Lordship. It's on page 57, Lordship. Arrest memo they have shown on 8 PM, Lordship. Long back after seizure has been made. On page 57 and page 59, Lordship.
Yes.
Lordship, I am relying on a Lordship order and Honorable Supreme Court's order where the physical custody has been.
No, but on what basis you are saying that physical custody? You were detained.
The basis of the seizure list and
Seizure list does not speak about your detention. It only speaks about seizure. After seizure, they have to verify whether it is contraband or it contains any prohibited materials or not. Only after that, if the police comes to a conclusion that after using this drug detection kit that you are possessing a contraband, necessity of arrest may be there. Mere searching you does not mean that you are detained. On what basis you are saying that you were detained at 8:27 AM? There has to be some basis.
Lordship, they have mentioned in the FIR that they have apprehended. The meaning of apprehension would be detained, Lordship, in the last paragraph of the FIR, Lordship. Page number 25, Lordship. Second last para. Thereafter, all the seized article along with 2 apprehended persons were brought to Gauhati GRPS and handed over the seized article for safe custody in the Malkhana. On the very same day, 2/4/25, after the subsequent receiving of the information of on 6:55 AM, then they have on 7:20 AM they have recovered, and on the same day they have taken 2 persons. They have apprehended both the accused present petitioner, Lordship.
When they were apprehended?
Time is not there, Lordship. Time is not there, but it is a subsequent.
How we will know that? Because time is crucial for you. the defense which you are taking, you have to show that you were apprehended on a specific time. When this affair was lost,
The fire was lost on 2/4/25 on 138 hours lost.
where is the date of lodging of the affair?
Then base 22 lodging.
Where?
Lordship, Lordship will find on first, second line, the date and time of FIR. There, the date is there and the time is there, Lordship. 13:38 hours, Lordship.
One 38. 1:38 p.m. When you were produced?
Been produced on
Three, five.
on 3/4 after Lordship 12 p.m. Lordship.
Where you were arrested? The time taken for traveling has to be subtracted.
Lordship, it is near to the court, Lordship. Gauhati CRPS, Lordship. Railway station, Gauhati Paltan Bazar railway station, Lordship.
What was the time of your production?
Time of production is not mentioned in the order. Order sheet neither in the forwarding.
Where is the order sheet? It is then burden shifts on you to prove that you were produced
Lordship,
after 1:38 p.m. on.
so that is why I have annexed the medical record, which has been medical examination, which has been done prior to the production of the accused person. The order is on page 37. Lordship.
Where is the indication of the where is the indication that you were medically examined before?
Lordship, before the production, it has been made. Lordship. The medical examination were done before the production.
On what basis you're saying? Because there is a mention that no medical report has been furnished. Thereafter, a direction was given.
Lordship, Medical was done before the production.
From where court will know? You show something to indicate that. You prepare, you go check the record. We'll take it up at 2. At 2, we'll take it up. If you fail to show, your application will be dismissed. Otherwise, we'll consider.
So I have other two grounds.
What ground?
Lordship, regarding the violation of section 36, Lordship, arrest memo.
Those grounds on earlier 2 occasions you have not taken. So on piecemeal manner you can take. You answer this question also. Suppose you fail to take some ground now. Again the ground which you could have taken on earlier occasion. Is it open to you for taking that ground on a subsequent occasion? We'll take it up at 2.
Deeply over.
Timing item 4.
Yes.
My Lord, Lordship will find, my Lord, the impugned judgment and order at page 30, my Lord.
Why it has come up for orders column?
Lord, I think, Lord, service regarding the respondent number 3.
Yes, 1 and 2
Yes.
have returned back with endorsement that no such person. What is to be done?
And so for respondent number 3 is concerned, my Lord, we have taken steps through, my Lord, publication items in the, my Lord, newspapers.
Okay.
That Lordship will find additional affidavit filed on, my Lord, 21/4/2025. So, my Lord, basically, my Lord, service to all the respondents have been, my Lord, completed.
1 and 2?
1 and 2, my Lord, in the order sheet says, my Lord, in the earlier it has been, my Lord, held that service has been completed.
Where? Which order?
Only 3 was left out.
Which order?
I have to check the, my Lord, order sheet because only 3 was left out. So we, my Lord, published in the newspapers in terms of the court's order and file additional affidavit bringing on record.
But 12/11/2025 shows that 3 has already been complete. You examine the record. Go through the order sheets and then make your submissions.
Lord,
We'll take it up after some time.
can it be posted any other day, my Lord?
Okay.
I'll check up it today, sir.
Heard Mr. M.U. Mandal, learned counsel for the appellant, who prays for listing this matter in the next week so that he can go through the record and make submissions regarding the service of notice on the respondents. Let this matter be listed on next week at the date due. On a date to be fixed by registry.
It may kindly be fixed.
It
Otherwise, it is very difficult to get fixed if it is not fixed.
At the date. Let the registry fix. Let the registry fix.
Obliged.
Hearing item number 14.
Lordship. Responsible as they may pass out for the timing also.
Lordship,
Can be taken up at 2, Lordship.
I will be tied up.
At two we have so many matters.
Lordship.
Any other date, because I was prepared to argue, but Mr.
Then-
Alam is tied up
Next,
somewhere.
court number 13.
Then we are adjourning it. Heard Mr. A. Bishwas, learned counsel for the appellant. Also heard Mr. S. A. Bhakhtiar, learned counsel for the respondent, who seeks an adjournment on the ground that conducting counsel for the respondent is on legs in a different court. Prayer is allowed. When?
Also next week, Tuesday or Thursday.
As your lordship, I will be here.
It is a part-heard matter.
Yes. That contractual dispute.
Huh?
On 26th, if it is possible.
Edes. Edes.
27th,
Oh.
28th, your lordship?
9th of June.
Okay,
9 June.
9th June.
9, sir.
Obliged.
One second.
Item number 15.
May I please, Your Lordship?
Yes.
Madam, this appeal is directed against the judgment and order dated 7/1/2013. Passed in way number 17.
Just a minute. ये तो कुंतु कैसे देगा? Yes.
7/1/2013, Annexer 1 at page 14, my lord, of this memo appeal, my lord. Whereby the learned RCT directed the railway appellant to make payment of rupees 36,796 on account of recovery of the punitive charge collected by the railway.
On account of?
Collection of the punitive charge for overloading or the
Okay.
consignment. The consignment of coal was booked from Jogigopa to SCB, Shannagar Junction, and at the time of on 20 booked in 40 consist of 40 wagon booked from Jogigopa to SCB Shannagar on 20/12/2000, waiting 2367.06 metric ton. Railway collected freight of for 3395.3 metric ton, including the usual freight alleging overloading of the 28 metric ton. So when there in Jogigopa Way Bridge, the consignment was weighted manner, then manner, it was in front of this consignor, and they acknowledge this women and make payment of the furniture without any protest. After delivery of this consignment to the destination station, they filed the claim application by claiming a refund of the freight charge for overloading of rupees 36,796 before the RCT. The RCT, by or judgment dated 7/1/2013, already after hearing the railway already contested the matter by filing the written reply. And after hearing both the parties, their RCT framed 3 issues. Whether the one issue is there, whether the applicant has served notice under section 106 of Railway Act 1989 to the respondent in time and maintainable, whether the relation of the panel paid by the respondent is justified. Now the issue number 2, already 1 and 2 already decided. 2 issues are decided. Then after in at page 17, my lord, issue number 1 and 2. Page 17 of our memo appeal.
Yes.
Last para, in terms of the Railway Board Circular so and so, 96 Railway Board Gazette notification number GSR 86 dated 21/2/97, the carrying capacity of the BCN is 58.
What is BCN?
This is the six-wheeled wagons minor for goods train for carrying this.
Now, what is the full form of BCN? And what is the full form of BCNA?
Yes, minor. This is the number of the wagons minor.
I'm not aware of the full
Yeah.
form. Basically, wagons consist of various BC and BSH.
My query is, what is the full form?
And satisfying Kubernetes.
Yes,
BCN, BSC and A.
BCNA and BCN.
Yes, madam, is 58.8 metric ton. The applicant booked 15 BCN and 25 BCNA. As per the prescribed carrying capacity, the weight is calculated as follows: 15 BCA wagon into 58 metric ton is equal to 870 metric ton into 25 BCNA wagon into 58.8 metric ton, 1470 metric ton. The total weight is 2340 metric ton. So and so by reducing 2-ton tolerance, it comes 2340 plus 80, 2420 metric ton in 15 BCN and 25 BCN becomes permitted. The applicant offered 2367.06 metric ton. A railway collected 2395.3 metric ton. During the course of argument, the applicant has stated that no fitness certificate of the weighbridge was submitted by the respondent and they have loaded the consignment as per load mark. There is an error on brake van weight. It is the fact that perusal of the record shows that fitness certificate was not submitted by the respondent and whether the weighbridge was perfect or not, the on date of the women is not clear. Therefore, in absence of fitness certificate, it cannot be conclusively proved that women is correct. In this case, my lord, railway already contested this matter before filing their written statement before the RCT. But RCT overlooked this. Women fitness certificate also submitted, but the RCT overlooked this document and submissions of the railway. So, my lord, in this my memo of appeal, my lord, I have taken ground, my lord. The in bound at page my lord 7, ground 15. For that, Lana RCT has discarded the weighbridge fit certificate, Exhibit 23 R3, issued by the State Meteorological Department, and viewed the weighbridge is defective without any supporting document. However, the weighment was done in the presence of the respondent. The respondent paid the said charge without any protest. As the respondent is not entitled for any claim as per the doctoring of stoppage. But in this case, my lord, railway already submitted fitness certificate before the RCT, which is marked as Exhibit R3. But here the RCT observed that no fitness certificate has been furnished by the railway. This is a clear violation of this submissions of the railway, my lord, and documentary evidence, my lord.
Apologies, my lord, for the interruption. The query which lordship raised with regard to BCN full form. BCN full form is bogie covered wagon. It is used to carry sensitive goods. And BCNHL full form is bogie covered wagon with heavy load, which is used to carry fertilizers, wood cranes, and heavy load.
BCNA means?
BCN bogie covered wagon.
And BCNA?
BCNHL means bogie covered wagon with heavy load. HL.
And what is the meaning of BCNA?
My lord, BCNA wagon is bogie covered watertight wagon with cast steel. It's highly technical, my lord.
No, not technical. What N stands for? In BCNA, what N stands for? You continue your research, later submit. Yes.
My lord, in this case, already
Who exhibited R3?
R3 the railway. R3 respondents documentary.
Records some.
Exhibit R3. My lord, the BC and A is bogie covered number A.
Bogie covered
Number A.
number A
A.
means
This is the some mark of the railways, my lord. The bogie is there's some wagons, there are some bogies
and
there.
BCN means
BCN, this is bogie covered number. It is the railways code number.
because you are railway council and he's defending lot of railway cases, but none of you are aware about the
This is the
abbreviation BCNN.
I'll try to obtain this circular and just.
Yes. R3.
R3, my lord. Where is found there, it in my hand also, my lord. The fit certificate was valid up to 24/3/2003.
R3 is not a fitment certificate. You have got
Where is fit certificate, my lord? Where is fit certificate?
Authorized. ये तो council of the Miss Chakravarti, you go through the record,
Yes, ma'am.
point out where is they are.
Here, my lord, page 77. Page 76.
But this is not exhibited.
But this is in record, my lord. It was exhibited, that's why it is in record, my lord.
What it says,
Fit certificate valid up to
valid up to when?
you have to one certificate and this up to 24 till the end of this certificate, my lord.
When the payment of the
When was done in 22/12/2000.
22/12/2000. You point out from in the fitment certificate since when it is. till when it is valid. What is your submission?
But that's why, my lord, when the women was done, my lord, that time the wages was fit in service, my lord. It was fit as per the report of the meteorological department, my lord. And
Where is that report?
so, my lord, this fit certificate is the evidence for showing the woman was fit for weighing the consignment. My lord, if the woman machine was not fit and the woman chart is wrong calculated by the railway, my lord, in the presence of the consignor, that time they could have raised an objection. Under section 79 of the Railway Act to revert this consignment. But this request was not made by the consignor, by the respondent. And subsequently, they made payment of the punitive charge as collected by the railway, my lord. So without any protest.
The section?
79 of the Railway Act, my lord, if we did, they agreed with the, if they are aggrieved with the payment of this railway, they could have requested the railway under section 79 for revert this consignment for authentication of this overloading. But this request was not made.
Okay. Thereafter?
Thereafter, my lord, the in ground number, my lord, 19, for that, at page 8, for that it may be noted that section 878 of the Railway Act empowers the railway administration to measure and weigh or reweigh the of consignment, and there is no provision for issuing notice for the purpose. There of the raise another question, my lord. The show cause notice was not issued, but the under section 78, the issue is not issued, but they have furnished a copy of the full bench judgment of this honorable court, the retapula of up to 333 of 2010, which was challenged before the Supreme Court, and Supreme Court decided in favor of the railway, then set aside this full judgment of order of this honorable court, my lord. Then no notice is required. If railway can weigh the consignment at the forwarding station also and load also. So in question of if any grievances arose by the respondent, they approach to the railway for reviewing the consignment for authentication of the overloading. But this was not made, my lord. So, my lord, further, in view of the provisions of Rule 3 of the Railway 20 charge of for overloading load wagon, Rule 2007, the railway administration shall recover 20 charge from the consignor, endorsee, as the case may be, for the entire distance from originating station to destination station point, irrespective of the point of detection of the overloading. Ground 20. Further, Rane RCT failed to take into consideration that railway administration has a liberty to remeasure, reweigh, and if it suspects overloading, recalculate the freight and other charges on the basis of the women. But the railway administration, being a transporter, service provider, is not required to issue notice for such acts, and then can be carried on in absence of consignor. The said reg wait at railway weighbridge for verification by railway and found that said consignment was overweight, and accordingly railway charge punitive charges under charges from the consignor, and the same has been evident from the weigh report dated 22/2/2000, 22/12, 2000, and the rate statement and detailed calculation. For that, ground 21, for that Rane RCT failed to take consideration that there is no provision in the Railway Act 1989 to ask the consignee to be present for the women done at railway. Since excess weight was found on women, railway had no other alternative that could collect punitive charges as per existing rule. Since the respondent applicant neither paid for women nor of wagon as per section 79 of the Railway Act 1989, nor paid punitive charge under etc. under any protest, question of refund of said punitive charge does not arise. Hence, the claim of the respondent applicant for refund of the said punitive charge is not admissible as the freight and other charges were collected against the subject invoice and RR was found to be justified. For that, learned RCT failed to take into consideration that the rule concerning testing of the said wave bridge was tested by Legal Metrological Department under the Standard Weight and Measure Enforcement Act 1985. And accordingly, verification certificate, fitness certificate was issued by the Inspector of Legal Metrology. Hence, the allegation of the respondent applicant are not applicable in this instant case. The London RCT failed to take into consideration that the respondent applicant had not adduced any evidence to show that such procedure was not being followed and inspection are not being carried out. In absence of evidence to prove the contrary, there is no reason to doubt proper working condition of the say waybridge at JPZ, Jogigopal. In fact, the respondent applicant failed to prove it has been overcharged illegally by the appellant petitioner and therefore respondent applicant is not entitled for refund. So, if we are wrong, my lord, in collecting the punitive charge for the overloading, it is their burden of proof lies on them to prove that our wage bridge was not fit and women's chart was wrong and wrongly railway collected the punitive charge. This evidence could not be produced before the RCT as under section 110 of the Railway Act, my lord. For that, compensation amount awarded by the RCT in the aforesaid imposed judgment dated an order dated 7/1/13 erroneously without considering the relevant provisions of the Railway Act and documentary evidence furnished by the Railway Administration. Hence, the imposed judgment decision of the RCT are highly arbitrary, capricious, and improper to be legally sustained and liable to be set aside and quashed. Then ground number 26, my lord, page 10, while the learned RCT deciding the issue number 1, 2, 3 failed to take into consideration that Railway Administration has a liberty to remeasure, reweigh under section 78 of the Railway Act. It is suspected, if it suspects overloading, recalculate the freight and other charges on the basis of the weighment, but the Railway Administration being transporter service provider is not required to issue notice for such acts, and this can be carried out on absence of the consignor. Moreover, there is no provision in the Railway Act 1989 to ask the consignee to present for the weighment learned railway weighbridge. Since the excess weight was found on women, Railway had no other alternative than to collect the punitive charge as per existing rule. Here, my lord, in para 27, RCT committed manifest error of law or not looking into the statement made in written reply of the railway appellant and the respondent to claim application of the respondent applicants, which are on the basis of the documentary evidence. As such, RCT has committed error in deciding the issue of negative to the appellant and respondents. My lord, in Indian Railway Commercial Manual Volume 2, my lord, there is a provision in clause 1878 of Indian Railway Commercial Manual, my lord. Okay. The punitive charges for overloading a wagon. Section 73 of the Railway Act 1981 lays down where a person made goods in a wagon beyond its permissible carrying capacity as exhibited under subsection 2 or subsection 3 or notified under subsection 4 of section 72, a railway administration, in addition to the freight and other charges recovered from the consignor, the consignee, or the endorsee, as the case may be, by charges by a penalty at such rate as may be prescribed before the delivery of the goods.
Which provision it is?
My lord, in the Railway Commercial Manual Volume 2, my lord. I guess I am giving. Okay. Yes, ma'am. This is the copy, ma'am. In para 1878, my lord, of the Indian Railway Commercial Million Volume 2, my lord. The next one, provided that it shall be lawful for the railway administration to unload the goods loaded beyond the capacity of the wagon if detected at the forwarding station or at any place before the destination station, and to recover the cost of such unloading and any charge for the detention of the any wagon on his accounts. When goods are loaded, my lord, there is a provision, my lord. If excess load was found, it can be offloaded, my lord. But under para 1877, disposal of excess offload consignment. In the Jogupa, when they have found there is excess of weight of this consignment, they could have offloaded this consignment, but they have not offloaded, but it is adjusted with the in other wagons on the for operational consideration. But it was already found in para 1877. Disposal of excess offload consignment. When as a result of wagon is found to be overloaded beyond the permissible limited, the railway reserves the right to have the excess weight removed. A separate record should be maintained whenever excess weight is offloaded. The railway administration may dispose of the such excess weight if offloaded by public auction and after following the prescribed procedure, sale profit will first be adjusted against the railway dues, which may be include the freight due on the offload consignment up to the point of offload, cost of detention of
In this case, how much excess weight was found?
128 metric ton. And here, my lord, in C, my lord, already clearly observed that whenever the railway institution does not offload the excess weight on operational consideration and to save the detention to wagons or for other reasons and allow the wagons to move the destination as it is, it will be within the right to recover penal charges for excess loading as provided in the course study. When they have not offloaded the excess weight, they can, for operational consideration, they can transport this excess weight
And
by
impo-
after adjustment in other work.
impose penal charges.
Yes, my lord. So, my lord, in good tariffs, my lord, in good tariffs rules, my lord, para 125. Para 161, my lord, punitive charge for overloading. It is the provisions clauses of this good tariff number 41, my lord. Punitive for overloading. When a person loads goods in a wagon beyond its permissible carrying capacity, charges as prescribed in the railway punitive charge for overloading wagon.
What is break van weight?
My lord,
Break van weight.
break van.
Break. Come to page number 17. Second last line. Page number 17 of the memo for P.
Yes, my lord.
Error on break van weight.
Break van weight.
What it means?
There is an error on the break van weight. Break van weight, it is a fact that pressure of the record shows that quick certificate was not submitted. Break van weight means if there is a empty wagon, maybe weighted, my lord. It is the difference between the weight of the wagon And after loading this wagon, before loading and after loading. Well, in the provisions of the good tariff, my lord, is the, in para 133, responsibility of owner in loading and unloading. In case of the where the owners of the goods are required to do the loading and unloading, as case may be the risks attending those operations.
No, you explain me in page 18, second paragraph. Page 18, second paragraph, what it means. Because I am not getting anything.
Respondent argued that brake van weight are not included with the calculation of the weight of the consignment. Brake van weight means, I think it is a,
Read further.
it is the empty wagon without consignment.
Okay.
Weighment of the wagon without consignment was not made, madam. Then when even if the version of the respondent is accepted, if it is a still remain a dark area, how Weber's has shown gross and tear brake van.
What it means, gross and tear of brake.
So there is a difference between the empty wagon and the weight of the empty wagon and the wagon with the consignment. What is the difference between these two? Really before loading, it is the responsibility of the consignor or consignee to load this consignment without supervision of the railway, and that's why railway is never required to weigh the brake van wagon, empty wagons. They are waiting only the after loading this consignment.
Tier weight is empty wagon.
Yeah. No.
Tier weight is empty.
Tier weight of the wagon
Is empty.
it is empty. This is the technical point, my lord, of the railway.
My lords, tier weight is the empty weight of the wagon. When the wagon is empty,
This is
And what is brake van?
the brake van is the same.
Brake van weight.
type, my lords. My lords may look upon the weighment chart. If my lords may look upon the
No, I'll come to you. Come to you. Let her submit.
This is the actual, but this technical one, my lord. The weighment are not included in the brake van weight. This is the tire weight of the wagon. The empty weight of the empty wagon was not made. When the wagon was already allotted to the consignor, they are loading their consignment themselves. Then after loading this consignment, they found there is a overload. This weighment was taken after loading, not prior loading. So when if the personal responsibility, it is a the respondent argued that brake van weight are not included with the calculation of the weight of the consignment. What is the difference between the empty wagon, weight of the empty wagon, and the weighment of the wagon with the consignment? The difference is not shown. Only in the woman chart, only how much weight has been carried out. This is shown, my lord. This is a technical procedure of the women, my lord. Then if the railway failed to show the brake van weight or the tire weight of the wagon, my lord, the burden of proof lies on the respondent, applicant. There's a difference between this weight. They are right, they are rightly loaded this consignment, there is no any excess load. It is burden of the respondent to prove. So this with the evidence, but this evidence was not furnished before the RCT. RCT overlooked the by taking the technical point, which means this granted this, allow this claim of the respondent without going through the railway commissions, madam. So, madam, in the para tariff maximum responsibility, in para 133 of the good tariff, the responsibility of the owner of the loading and unloading. Even in all cases, owners of the goods are required to do the loading and unloading case may be, and the risk attending this operation shall be borne by the owners. In
Which para you are reading?
my lord, I am the good tariff, my lord. My lord, I have not submitted it in my hand, my lord. This is a good tariff of tariff 41, my lord. In para 161. There are 61, my lord.
Para?
161. Last page, last page, my lord. Printed charge for overloading. Where a person loads goods in a wagon beyond its permissible carrying capacity, charge as prescribed in the railway printed charge for overloading wagon rule 1990 are recoverable from the consignor, consignee, or endorsee. A copy of the railway, this is a rule, madam.
Where is this rule? Railway
Yes.
punitive charges law.
It is already in 1990, but it is further amended in the year 2007, my lord. Again is amended in 2012. My lord.
Dhiraj.
Yes, my lord. It is a 1990.
To railway punitive charges for overloading of wagon rules. Library Prohibitions Unlimited.
My lord, my Mr. help me. The brake wheel wagon is a specialized vehicle placed at the near of the train to provide essential braking power for freight. Accommodate the guard for safety monitoring and ensure the train stops safety in emergencies. This is brakeman wagon manners. Then in all trains, there is some brake. If any emergency and any necessity, the brakeman can be used by lot. It is by pulling a chain or by signal of the driver.
Okay. So it is something to concern with brakes. How it is relevant in overloading and
It's a guard wagon, man.
so why it
Last
is,
week.
why it is mentioned in the this
brake van wagon. This is the another facility to the railway train pilot. When who is carrying the wagons? If any for safety, this it was brake van was issued. This is separate matter. This is not related to the overloading matter.
then why it is mentioned? Therefore, I am asking.
It is a mechanically RCT pass this assessment matter.
The RCT has mentioned that there is an error on brake when weight. How it is relevant to the present? This you have to answer. Take note at your
This is the break bin in all passenger mail train also break bin is there. If any necessity for safety, this break bin is used, my lord. This passenger also can stop the train by pulling the chain, but driver also can stop by pressing his brake bin. For the it is a safety train stops safely in emergencies. This is not relevant in this case, present case, my lord. Here the question is whether railways corrected the printers rightly or wrongly. Whether women wish to are fit or unfit, and whether women chart is wrong. So if railway collected the consignment, so these women wages of the Jogigopa in presence of the consigner, they have no raised any objection in this regard, and they paid this printed chart before transporting the consignment and without any protest. Now they are raising that there is no any overloading, their women fit, this was unfit without.
The payment was made in presence of the consignor, where it is there, where it is mentioned.
Payment was loaded from Jogigopal. And the payment was done not in end road, it is destination, forwarding station. And at this 23rd charge along with the other freight charges. More than 16 lakhs they have paid for the transportation of the coal consignment from Jogigopal to Prannagar. Now that when they are paying the freight charge as per RR, railway receipt, and in forwarding note means, my lord, they have whatever they have loaded, they have written in the forwarding note as per their statement, and railway collected freight on their statement. Railway has not supervised how much consignment was loaded or not. As per their statement, in forwarding note, railway collected the freight. Then after that, when they where the consignment again before transporting, then when they found there's excess load, then they charge the 20 charges. So in this case, they paid before transportation of this consignment. The respondent paid the 20.
Have you filed any written
Yes, my lord.
reply before the tribunal? Where is that?
55, what? Yes, my lord.
$55 of the
SPCR, my lord. My lord, WS written statement at page 55 and the forwarding note R4A page 40 to 46. Affidavit is page 73, railway affidavit, and the fitness certificate page 78. Railway all submitted all documentary evidence, but RCT overlooked this documentary evidence and passed this order mechanically with as per his own decision, without going through the submission of the railway and documents of the submitted by the railway. So on what ground they have denied the railway is not entitled to collect the plaintiff charge? It is wrongly observed, my lord, here, which is not relevant. In my affidavit also, I have explained everything, my lord, page 77.
No, the consignor claims to have loaded 236,706 metric ton. You found it excess when you weighed. Where is that statement?
52/12/2002.
Where is that statement? In your written statement, where is that statement? When you found.
My written statement, my lord. In para 7(6), answer to para 7(1), that it is denied that applicant had offered 236706 metric ton of coal. It is also denied that chargeable weight is 2420 metric ton, but it is submitted the terms of weightman chart marked as exhibit R3. The applicant had loaded 2367.06 metric ton of coal in the rake distributed in different wagons as per the weightman chart and declared the same in the forwarding note, my lord. The excess weight already declared in the forwarding note also.
No, you read properly. It appears that the applicant has, as per the weighman chart, has loaded only 2367.06.
Statement of the consignor.
Okay, when you found excess weight, where have you found the excess
In
weight?
forwarding note, he already showed that he had loaded
Where is that?
6706 metric ton, my lord.
Yes.
We have accepted. As per their forwarding note, we have accepted this weight.
Okay.
After loading this consignment, when we, before transportation, when we weighed this consignment.
Where is that statement that you weighed again?
This is the weightman chart, my lord. Weightman chart is there. As per weightman chart, when we have weighed the consignment. As per weightman chart.
No, in your written statement, you have not mentioned.
My lord. Yes, my lord. Yes, my lord. But in para 6, my lord.
Yes.
It is denied that applicant had offered 2367.06 metric ton of coal.
Okay.
It also denied that chargeable weight is 2420 metric ton.
Yes.
But it is submitted in terms of the weighman chart marked as R3 that the applicant had loaded
The same amount, same weight.
of coal in the rack distribution in the wagons as per the weighman chart, but declared the same in the forwarding notes. This is their relate accepted on the as per the forwarding note. What is declared by the consignor?
I am not understanding anything.
When the forwarding
Listen, Ms. Chakravarti, the applicant, while booking the consignment, has mentioned that the weight of his consignment is 2367.06 metric ton, which you deny. You say it was more than that weight. Then you say that he has declared in weighman chart the same amount, same weight, 2367.06. Where is the statement that you found excess weight beyond the weight which has been declared by him?
Yes, ma'am. In forwarding note, it is found at 236.7.06 metric ton.
Yes.
I have accepted it. After weighman.
Where is that statement that you weighed,
Yes, madam.
that you collected freight for 2395.3 metric ton? On what basis you collected 2395.3 metric ton?
Madam, here, yes, madam. In para C, next page.
There are 6 of the.
There are 6 of the written statement. It is submitted that concerned have underloaded some wagon for which freight were charged on the minimum prescribed rate as per
Where are you reading?
of the my written reply, my lord, WS.
Which para?
Para C.
6A, B, C.
It is 6A, B, this is C. Next page, my lord.
Yes, C.
It is submitted that concerned have underloaded some wagons for which freight are charged on the minimum prescribed weight as per rule. Some wagons were loaded up to 2 tons excess and for which freight charged at normal tariff as per rule. Only wagons those are loaded more than permissible carrying capacity plus 2 tons. 20 charge were levied only on the excess weight as per rule. The respondent followed the rule prescribed by the railway board central government, and there is no any fault in charging the freight as they not and noting it's refundable. Nothing is refundable. It is submitted that permissible carrying capacity is always calculated on the individual wagon only. The weighman chart shows that they have loaded 23670 metric ton distributed into 40 wagons. The applicant made a calculation which is based on gross total weight of the whole consignment loaded in several wagons, not individually, which is against the rule. The applicant is as such not entitled to get the benefit of the violation of rules. It is submitted that freight charge according to the provisions of the rule, as the application is liable to be dismissed. The payment was done in individual wagon pilot, not as a whole. The only two plus two
Where is the payment chart?
women chart is in my
Page number 67 of the LCR file. I have flagged. Serial 41 is break one, my lord. Serial 41. Payment charge.
41.
Here also, as per payment chart also, the total weight comes to 2367 plus 0.36. My query is on what basis you have come to a conclusion that the total weight of the consignment was 2395.3. How much is the difference? 239.5.
28 metric ton. 28 metric ton.
No. Now, where is that figure 239.3? From where that railway got that figure?
In my affidavit, I think they have explained about page 77, my lord, railway's affidavit.
Page 77.
Your lordship, there is a difference of 28 metric tons.
28.24.
28.24 metric tons.
Now, where is the calculation of railways? That
Calculations, my lord.
2395. Where is that chart? From where they came to this figure?
Record. Calculation of the revenue.
Is it your submission that you maintain the registers, but registers have been destroyed now?
Yes, madam. That's why, my lord, we cannot provide this calculation, my lord. So already, it was already, this web overcharge already, overloading already accepted by the consignor. That's why they paid this 20 charges, my lord. If it is not a overcharge, overloaded, my lord, the question of making payment of the printed penal charge does not arise, my lord. They paid without any protest. But they have accepted there is overloading. Only in para C, my lord,
This refund is claimed under what provision? Before Railway Claims Tribunal, you claimed refund of the section 13. Is there any limitation period for filing?
My lords, there is the only requirement to serve a notice under section 106. We have the discretion even if we do not make any protest and make the payment. The only requirement is to serve a notice under section 106, and after receiving that notice within the 6-month period, the railway.
What is the limitation period for serving notice?
6 months.
6 months.
So you have served that notice.
Within
So
that-
during that period, you have to maintain the registers.
Yes,
You
ma'am.
cannot destroy the registers.
And there are IRCM rule and judgments as well, my lord.
No, otherwise also common sense says, if that is your basis on which you are imposing excess charges, some documents have to be there.
This register was not maintained, only really accepted. Register is not maintained, my lord.
Then what is the basis on which railways claiming that this was excess, 28 metric ton was excess? On what basis?
The basis of the women chart, my lord.
But weighment charge shows,
The same, my lord.
it does not show excess weight. Weighment chart which is there on record,
Yes.
it only shows.
But
Sure.
My lord,
the
if I-
reply also, that was not done, my lord.
My lord, if I may, these are.
I'll come to you.
Okay, my lord.
In your written statement, you have only stated that
Yes, but if I could not have to submit this in my register, how I have calculated the access to
yes.
it. So, my lord, if there is no overloading, no excess weight, then why the consignor made payment of the 36,900, 700 something before that transportation of the wagon.
No, otherwise you will not release the consignment.
That they could have request the railway to further revert the
But
consignment.
there is a provision that they can issue a notice under 106
106.
within 6 months.
6 months they have
That
issued.
means that they can, even if you charge excess to get the delivery of their consignment, they will make payment and later on they may protest under 106. So during that period, you have to maintain the registers. Otherwise, Railway Claims Tribunal has held that you have made and mentioned an imaginary weight without any basis. Now, why the Railway Claims Tribunal was wrong? You have to show something. Now you don't have any basis to show that it was in excess by 28 metric ton. Do you have anything to show?
I have to obtain instruction. I don't have any records at present in my hand.
Okay, let them reply.
Yes, my lord. So 1 week time may be granted, my lord. I will issue. An opportunity may be granted, my lord.
No, whatever is there, it is there in the records.
Yes, my lord.
Nothing else will come.
They submitted this women chart at the forwarding notes.
No, you go through the record. It has to be there in the
Yes,
trial court record.
yes, my lord.
Yes, Mr.
Then I have to go through the record, my lord.
Yes, my lord.
What is your submission?
That's the first submission which I'll make. If your lordship may kindly have page 3 of the impugned order.
Yes.
My lords, at the very bottom, a detailed calculation, the fourth para, my lords. In terms of the railway board circular dated so and so, the carrying capacity of the BCN wagon is 58 metric ton and BCNA is 58.8. And after thorough calculation, the applicant offered 2367.06 metric ton and railway collected on 2395 metric ton.
What is the difference between BCN and BCNA?
My lords, we are just obtaining the circular from our office, my lord.
Okay, continue your submission.
My lords, the tribunal has recorded that during the course of the argument, the applicant has stated that no fitness certificate of the weighbridge was submitted by the respondent.
That was the one ground.
That
was one ground.
Yes, my lord.
Yes.
Yes, my lord. That's one ground, and my lords, even the tribunal has recorded that no payment certificate has been issued, my lords. It is the fact of that pursual of the record shows that the fitness certificate was not submitted by the
Okay,
respondent.
what you come to line number, second last line in page 17.
Page 17.
In the impugned judgment, page 3.
Page 3. Yes, my lords. Second line.
Read the second last line.
During the course of the argument, from there, my lord.
Yes.
During the course of the argument, the applicant has stated that no fitness certificate of the weighbridge was submitted by the respondent.
That is okay. That is understood.
And that they have loaded the consignment as per load mark.
Okay.
Thereafter? Yes, my lord. There is an error on brake van weight.
What it means?
Yes, my lord. If your lordship may kindly have
fitness chart.
Weighment chart, my lord.
Brake van weight is 0.
If your lordship may
It
kindly
is mentioned as 0.
I'll just show my lords.
I have gone through it.
My lords, in that there are 3 columns. First column is carrying weight capacity. Second is gross weight tons, and second is tear weight ton. My lords, if you see, my lords, the gross weight ton is 14.06 and the tear weight ton is 14.0. If the wagon is completely empty, then it should be completely same, my lords. It should be the same, similar numbers. However, they are different numbers, which itself shows that the weighbridge were defective, my lords.
No. What is the submission?
My lords, have serial number 41 in that weighment chart. In the serial number 41, there are 3 columns. Firstly is the carrying capacity, which is at the top, if your lordship may have it.
Yes.
The second is gross weight tons, and third is tear weight tons. My lords, in this, the gross weight ton and the tear weight tons should be the same because it is the empty vehicle.
Why?
Sorry, my lords?
Why it should be same?
My lords, because it is an empty wagon and no consignment was loaded in that wagon. And if no consignment was loaded in the wagon, which means it's a tear wagon. And
no, how you are saying no? It is gross weight is the low weight after loading of the consignment.
Yes.
Therefore, it comes to total 36.
Yes, my lord, and the net worth turn is showing 0.00. I've shown. And the net weight turn is showing 0.00. Which itself shows, my lord, there is a discrepancy.
What is your submission?
My lord, my submission is that there has been a discrepancy in the payment in the weighbridge itself because it has not recorded everything very properly. And even
you take one example. Brake van 41.
My lord, at serial number 41.
Yes, that is brake van.
Brake van.
The gross weight is 56.30.
It's a guard wagon, my lord. It's an empty wagon. And it is showing, the gross weight is showing 14.06 and the tear weight is showing 14.00. And the net weight ton is showing 0.00, my lords. And it's a guard wagon, my lord. It is supposed to be empty.
What is this gross weight?
The total of the gross weight tons and tier weight ton, my lords. It's the total net weight. Sorry, my lords, gross weight ton minus tier weight tons, which is the net weight ton. If your lordship may kindly have at serial number 40, if you can see, my lords, that it is showing 88, gross weight is showing 88, and the tier weight is showing 25. And after deducting it, it is showing 63. However, in this, my lords, in the payment chart in serial number 41, it is not showing that.
What is the last column?
41, my lords. It is a break when, my it is BV, my lord. It is showing
No, no.
BV. It is break when, my lord. It
The
is supposed
last column, not row.
last column, which is speed, my lords. Last column is speed.
What is this?
My lords, does
You come with full instructions.
my lords, if my lords, may I make 4 more submissions, my lords? If your lordship may kindly add, there's a judgment, my lord, fuel source judgment, which I have given. My lords, in that judgment, at para 10, this court has observed. My lord, it has similar facts.
Yes.
Similar facts, similar party, everything is same, my lords. It says that this court has duly taken note of the provision to section 73, and from the said, it is seen that the railway administration could not have permitted carrying out of any load beyond the capacity of the vehicle that when
No.
it detected at the forwarding station, my lords.
That rule which has been shown by the Railway Council, that is Indian Railway Commercial Manual. It shows that even if it is not offloaded for certain reason, administrative reasons are mentioned in that, then it can impose. It is not necessary.
My lords, the act will prevail over the rule, my lords.
Where is the act?
My lords,
What?
My lords, may kindly have section 73.
What it says?
My lords. My lords, I'll read it out. Where a person loads goods in a wagon beyond its permissible capacity, as exhibited under subsection 2 and 3, or notified under section 70, under subsection 4 of section 72, railway administration may, in addition to the freight or any other charge, recover from the consignor, the consignee, or the endorsee, as the case may be, charges by way of penalty at such rate as may be prescribed before the delivery of the goods, provided that it shall be lawful for the railway administration to unload the goods loaded beyond the capacity of the vehicle if detected at the forwarding station or at the place.
Yes, that is an enabling provision.
Yes, my lords. And after considering this provision, this court has observed that if the overloading has been detected at the forwarding station, then the railway is required to offload the consignment. That's what I'm trying to show, my lords. If your lordship may kindly have para 10, my lords. It's all I'm trying to say. After considering the whole complete proviso of section 73, this court has duly taken note of the proviso 73, and from the said, it is seen that the railway administration could not have permitted carrying out of any load beyond the capacity of the vehicle to when it was detected at the forwarding station. And my lords may kindly have another judgment, which is unique coal. My lords, it is MFA 32 of 2013. My lords, may kindly have para 9. Considered the submission of the learned council, Rule 1432 of IRCM stipulates that all weighbridge will be tested half yearly by.
Where are you reading?
My lord, para 9.
Yes.
My lord, have it.
Yes.
Considered the submission of the learned council, Rule 1432 of the IRCM stipulate that all weighbridge will be tested half yearly by Inspector Mechanical so and so department. Rule 1435 stipulates that the station master who tested daily the weighbridge and weighing machine must make a note of the test in the weighbridge register and tally book, and if it transpired that the weighing machine is out of the order, repairing of the said instrument ought to be arranged immediately. As per the present dispute is with respect to the overloading, and that too in the presence of the railway staff after making height of the loading of coal in the wagon, as such coal landing so and so as such code landing as per the goods tariff number 2, wherein it has been specifically mentioned that the booking staff should ensure that the loading of the coal beyond the required height is not allowed. In any case, if coal is found loaded beyond the permissible height, the staff at fault will be taken too seriously. My lords, now kindly take note of it, my lords. The railway appellant is empowered under section 73 of 1989. If there was any overloading, then the same ought to have been unloaded, and as against the cost of such unloading and any charge for detention of any wagon on that account was not informed to the respondent consignor. It is the contention of Mr. D that as the detection was at the starting point, at such there is no requirement of any such notice, because immediately on its detection penalty was levied, which was paid along with the freight by the respondent without any protest. That cannot be accepted until and unless some definite proof for presumption must be on record, and said record, in my opinion, is the coal loading height register and the unloading charges so levied. In addition to that contention, Mr. M.S.M. Sharma is to be accepted in as much as the coal was booked under the owner's risk. My lords, in our case as well, the consignment was booked in owner's risk. And as per section 79 of the Railway Act, and its proviso applies in the case of the present respondent. My lords, it is the similar facts, my lords.
No, what similar? What is your submission?
My lords, my submission is, if the overloading has been detected at the forwarding station,
Yes.
then it should be offloaded, my lords.
If it is not offloaded,
My lords, the railway,
no, if it is not offloaded, then what happens?
my lord, the railway do not have the power to
Then
impose
they-
punitive charge, my lord.
Okay, then what is your say on this rule 1877 clause C of Indian Railway Commercial Manual? Take this into the.
Does not offload and the excess weight.
Give him.
Okay.
1877 clause C.
CC.
Yes, my lord.
Read it and make your submission.
My lord, I'll read the entire rule if your lordship permit. Disposal of excess offloaded consignment.
No, not that.
CC.
C
On
on.
the C part, whenever the railway administration does not offload the excess weight on operational considerations and to save detention to wagons or for the other reasons.
So it means that offloading may require some time, may have to keep the wagon detained, thereby disturbing the journey of the entire train. Therefore, in certain circumstances, though it may offload, what I have understood, make me understand if I am wrong.
Yes, my lord.
For administrative reasons, for other operational considerations,
Yes,
the railway may not offload the.
lords,
How you explain C?
lords, I'll say that some authorization must be granted to impose punitive charge, lords. To carry the overloaded vehicle. My lords, if
No, in this case, the railway is unable to show on what basis you computed. There is no material. So your case appeal may not, it may have to be dismissed on that ground unless you show. I am giving you time. But as of now, you are unable to show that.
I have to obtain instruction and how they have found it.
But that has to be there in the records,
Yes, sir.
either trial court records or in the.
If it is not in trial court record, then it is not possible to give out. So my lord, I will try my level best, my lord.
If your
to find-
lordship may kindly have it at 2 p.m., my lord.
Not
See
2 p.m.
The instruction.
Not 2 p.m.
Yes, we'll have it on 2 p.m. on some other day. Heard Miss U. Chakravarti, learned senior. I have raised certain queries.
Yes.
Learned Senior Railway Council appearing for the appellant. Also heard Mr. D. Rathi, learned counsel for the respondents. During the course of the submissions, certain queries were raised by the court. Learned counsel for both sides have. Now, learned counsel for the appellant has prayed for some time to take necessary instruction and reply to the query posed by this court. Let this matter be listed. When?
Zero city power.
Short date.
Last week, first week of the June.
9th of June.
9th of June, my lord, I have another case, my lord. 10th,
My lord, 10 also.
11 June. No,
11. Yes.
11 June.
11 June.
My lord, may keep it at part or
11 June at 2 p.m.
grateful.
It may be kept as part heard, my lord.
as part heard
As
matter.
part heard, my lord. I don't think they know them. No, no. उम्र कितना है तुम्हारा?
Yes.
My lords, in the next item itself,
Maybe taken on
my lord,
11th
it's a
June,
covered
my lord.
matter, my lords. It's a demand after delivery of the consignment, and the Supreme Court has settled on this position.
Not what, this is not after
My
delivery, my
lords,
lord.
Supreme Court is
In
very
item
important
16,
textile has
there
settled
is-
this issue.
There are different issues, my lord. The common judgment is passed in a two matters, my lord, not in a similar matter, in violation of the rule 24 of the Railway Claim Table Procedures, my lord. So, in one side it is a plaintiff charge, in another side it is graded concession.
Now, what is your submission now? Should we hear it?
No, my lord, it on 11th June.
Why? Why?
I am not feeling well, my lord.
Okay. That is a valid.
Yes, my lord.
Heard Miss U. Chakravarti, learned Special Senior Railway Counsel. Also heard Mr. D. Rathi, learned counsel for the respondent. Learned counsel for the appellant has prayed for an adjournment on the ground that she is not feeling well. Considering the ground, the prayer is allowed. Let this matter be listed.
With 11 June, my lords. Similar, my lords. Overloading matter after delivery, demand after delivery, my lords.
On
covered
11 June.
Supreme Court judgment.
Yes.
11 June.
Grateful.
Much obliged, my lord.
Item number 17.
এইটো এটা সেপারেট ফাইল বনাবো মিটা কৰি বনাই রেকর্ড 17 রেকর্ড করে Yes.
Your Lordship, kindly pass over the matter for time being.
Why?
My senior is in another court.
Okay.
Item 18.
Yeah, please, your lordship. Lordship, my senior is on his way. Lordship.
What is the prayer?
I am further responded. I'm ready, man. They can stop.
But you have to start.
Yes, you know. He's on his
You
way.
are the appellant. You tell me the facts at least.
I don't with me right now. He will be hearing any.
Now don't look backside.
He will
You
be-
go through the file and read the facts and then tell me the facts. Let him go through the files. We'll take it up as next matter. You go through the file. Next item.
Item 21.
May I please, Your Lordship?
Yes, what is this? Yes, you're not ready?
I'm just, because there was a review by the insurance company. I am the claimant, Your Lordship. Earlier, I filed a claim petition, Your Lordship, that was allowed. The amount was less, obviously. There, in that claim petition, Your Lordship, the insurance company did not appear, Your Lordship.
It was expertly.
It was expertly.
Okay.
And they filed an application for review. And in the review, my lord, the review, page number 34, my lord, may kindly see. This is the page number 34, annexure 6, my lord.
Yes.
This is the order in review, my lord. Only one ground they have taken in the review, that is, my lord, because I was driving the driving the motor vehicle, so I stepped in the shoes of the owner, Your Lordship. Therefore, the Nigama, citation, they relied upon the citation Nigama, Your Lordship, and thereafter the awarded amount rupees 66,224 was set aside, Your Lord.
How much was awarded earlier?
Rupees 66,224, Your Lordship. My
Okay.
initial so only on the basis of that Nigama judgment, the earlier my claim judgment that is on, my lord, that was set aside, Your Lordship. Now, my lord, judgment starts from page number 19, Your Lordship, where the insurance company was expert, Your Lordship.
No evidence was adduced by the insurance company.
The owner appeared in the and filed a written statement, Your Lordship. Because
In review application itself, the earlier judgment was set aside.
on the ground that I was, because since I stepped into the shoes of the owner, Your Lordship, so third party claim denied, Your Lordship. So, my lord, only a simple issue, Your Lordship, that, my lord, even if I step into the shoes of the owner, Your Lordship, my lord.
When in review it was found that there was some error apparent on record, then the law says that the judgment under review has to be vacated and the parties are to be heard again, and thereafter you read Order 47 Rule 8, take CPC. CPC. Yes, Mr. Saikya. CPC नहीं What is your submission?
My lord, before going to that, my lord, because I have challenged, my lord, the judgment is in page number 19, Your Lordship. It starts from page.
That judgment has been set aside.
But there were apparently, Your Lordship, because, my lord, my contention is, Your Lordship, though I was
Now you read Order 47 Rule 8.
My lord, can it be taken after
First you read. we will dispose it of if. Or you come prepared after going through all the 40, whether the even if the court finds that there was error apparent on record, then in review, original claim petition could not have been set aside. It ought to have vacated the judgment under review and given you chance. Both the parties have to be heard again. That is the mandate of Order 47 Rule 8. On that, you make your submission on the next date. Yes, Mr. Sakia, do you have heard Miss, what is your name? SSGR Learned Counsel for the appellant. Also heard Mr. H. Sakia, Learned Counsel for the respondent / insurance company. On request of Learned Counsel for the appellant, this matter is adjourned for the day. Let this matter be listed again when? No, next week. 9th June. 9 June.
Public.
Item 18. Wait, please, Your Lordship. Lordship, this appeal against the judgment and award dated 16/6/2017 passed by the Learned University, Karimganj. Now, the appeal here, the person claiming is the father of the injured. The facts are that when the injured was riding his motorcycle, the offending truck dashed him, and thereafter he sustained certain injuries. Now, the injuries included head injury with permanent leg impairment, which led to shortening of leg and loss of teeth. Now, due to such injury, he has taken treatment before the SMCH, and thereafter the doctor of the SMCH, he has examined him and has issued a disability certificate stating that due to the injury sustained, it has led to a physical disability of 10%. Now,
Physical disability of 10%.
Thereafter, the what did the Learned Tribunal do? The Learned Tribunal went on to discard that and self-assess the loss of earning capacity at 100%, which is totally arbitrary. Because first of all, the tribunal does not have the authority to self-assess the disability based on which the loss of earning capacity has been reassessed at 100%, in spite of the evidence of the doctor being there at to the tune of 10% physical disability.
Where is that 10%?
I'll start reading from issues number 3 and 4 at page 9. The paragraph starts with paragraph 6, as it has been held.
Yes.
I'll read from that. As it has been held, the truck was under the valid insurance cover with the opposite party number 2, and that the accident was caused by the rash and negligent driving of the driver by its driver, who was a servant of the opposite party number 1. And also it has been held that the victim suffered serious injuries, making it undeniable that he must have incurred expenses in his treatment, being vicariously liable for the acts of the driver, the owner, and being under the contract of the indemnity. The OP number 2 are held jointly and severally liable to pay compensation to the victim. It is further held that being under the contract of indemnity, the opposite party number 2 shall pay the entire compensation to be assessed as follows. The claimant witness number 4, Dr. A.K. Daula Kapoor, the professor and HOD of orthopedics in the SMCH, and also the chairman of the special medical board constituted for assessment of the nature and extent of injuries and disablement suffered by the victim Zakir Hussain Talukdar,
has deposed in his testimony that on examination by the medical board, the right lower limb of the victim was found 2 centimeters short, causing permanent physical disablement of 10%. He has also deposed that 2 of the teeth of the victim were also found missing, and that because of the head injury suffered by him, he has suffered intellectual impairment, reducing his intelligence quotient to 60, and that he requires further assessment and evaluation by neurologist and neurosurgeon. He has exhibited the report of medical board as Exhibit 19, which substantiates his version in his examination in chief. During cross-examination, the same could not be rebutted and rather got reinforced by his statement that the permanent disability was assessed at 10%. The claimant witness has exhibited the HS school certificate showing the victim was 10+2 past person, and therefore, in absence of any counter from the opposite party too, it can be taken as a substantive proof of the fact that the victim was having an average IQ ranging between 90 to 110. This shows that the accident has caused serious impairment in his intellectual capacity. It is to be noted that this tribunal is concerned with the loss of earning capacity for assessment of compensation to be paid. And in that sense, as it can be safely presumed that a person of IQ of 60 cannot be employed in any employment, the loss of earning capacity of the victim has to be assessed to be 100%. Loss of 2 teeth.
No, that means the tribunal has not considered the disability of your limb. It was considering the intellectual disability, reduction of the IQ.
Yes.
Only that has been taken into.
Yes. So whether the tribunal is empowered to do that, that is one question.
Do what?
To reassess the earning capacity of the.
No, earning capacity is to be functional disability.
Yes.
Loss of earning capacity is to be assessed by the tribunal only.
By the tribunal.
Only physical disability is to
To
be.
be assessed by the doctor. But the loss of earning capacity, that will be based on the assessment of the physical disability.
Yes, physical disability is IQ is reduced to 60%.
60%. Now, where is that schedule or where is the provision which says that this IQ leading to 60?
No, you show that a person with 60 IQ can do.
No, and another point is that the loss of earning capacity, that has to be based on particular employment, that before the accident, this person was doing this employment. But herein, at para 7, your lordship will find that the victim was having monthly income of 15,000. However, no evidence of the victim being actually and gainfully employed has been furnished. So at the time of the accident, he was not gainfully employed. So whether this loss of earning capacity assessed at 100% could be taken into account.
What he was doing for earning?
That is not there. Nowhere that could be proved. Under that circumstance, the income was taken at 5,000 per month.
Daily wage, minimum wages.
Yes, minimum wages. So the proof the fact that he was gainfully employed before the period of accident, that is also not there. So under such circumstance, there is a case of remand where your lordship would remand the matter back to the tribunal to reassess whether this IQ leading to 60%, that has an impact on the earning capacity, or the physical disability that can be increased from 10% to further up.
Okay, we'll continue with in the second half. Yes.
I'm sorry to mention. This is item number 23, my lord. I think the lordship has fixed some matters at 2. The problem is I have also a matter fixed at 2 and 1.
What is your prayer?
My prayer, my lord, may taken up it. This matter may be taken up on another day.
It's for the other side. You have any objection?
No.
Heard Mr. S. Chakravarti, learned counsel for the
Railway. Appellant. This is an appeal under section 37 of the arbitration.
Yes, learned counsel for the appellant. What is your name?
K.M. Halloy.
Also heard Mr. K.M. Halloy.
For sole respondent.
For the sole respondent. This matter could not be taken up for hearing today. Hence, let the same be listed. We are not giving any fixed date.
He is enjoying stay. So
It's a 2020 matter and
Then it will go to August. Give a date.
can it be in the month of June?
June will already.
Because
June we are full.
5th of June. Because it will not take much time.
It will take some time. It will not
Take much
It
time.
will not take much time. Because
that means it will take some time.
Sometime.
That some time is not available with.
4th or 11th, 4th June will be possible. 4th or 6th.
Yes, Ramesh.
4th June if possible. Hearing date. Eleventh. 11th I have part head matter fixed. On 9th.
4th of August. 4th of August. Yes, Mr. Talukdar.
Proceed. So far as item number 34 is concerned, part had matter loss, it's small point involved in this case.
Yes. What is your prayer?
Let it be taken up at 2.
We'll take it up. You wait for your turn. At 2, we have other matters. We'll take it up today. We'll take it up today. Yes.
My item 26, my lord, hearing matter. Kindly, Araswati consent error. Kindly, this matter will be listed after 2 weeks, my lord.
What is your name?
Miss D.J. Bora. Date may be fixed, my lord.
No. Heard Miss D.J. Bora, learned counsel for the appellant, who prays for an adjournment. She submits that she has informed learned counsel for the other side regarding her prayer for adjournment, who has no objection for the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
15 June.
My lord, may I make a mention at serial item number 36 and 37?
Yes.
My lord, I have traveled from Indore, my lord, for this particular matter, my lord. But the opposite arguing counsel, Mr. Maurya, is not available, I guess. So they wanted an adjournment. So this may kindly be fixed with order sheet reflecting that it would be applied positively on the next day. That's the only request.
Now, what do you want?
It may kindly be fixed on a particularly fixed date, my lord. And the order sheet may kindly be reflect that the matter would be argued positively on the next date of hearing, because I have to travel from Indore each time, my lord. So they also
Argued positively means what?
they also agree, my lord, that they will argue the matter, my lord, but the order sheet may kindly reflect that.
Suppose if it is not reflected in the order sheet, then it will be not heard. Would it mean that it will be not heard?
No, definitely not, man.
Then there is no necessity of mentioning that.
As your lordship.
Heard, Mr. What is your name?
Ankit More.
What is your name?
P. Pravar.
P.
Pravar, P-R-A-W-A-R.
Item number?
36 and 36.
P. Prabodh.
Pravar. I'm appearing on behalf of Mr. H.L. Moria.
P. Pravar. Appearing on behalf of Mr. H. Moria. You come in this on this side. You are for the respondent.
And for the appeal.
Let's see what it says.
Then why you confuse the court by?
In Indore, like in MP High Court, we stand that.
But this is not MP High Court.
I was not aware of that. A lot of apologies.
Also, Mr. What is your name?
Ankit More.
Ankit A. More, learned counsel for the appellant. Learned counsel for respondent has prayed for an adjournment on the ground that
Mr. H.L. Moria is not well. The conducting counsel, Mr.
that
Chairman.
conducting counsel for the respondent, Mr. H.L. Moria, is indisposed, is not well or not available.
Lordship, he was in the court, but he got sick and he had to leave for his home.
Oh, he is indisposed. Though learned counsel for the appellant is an outstation counsel, however, considering the grounds stated by learned counsel for the respondent, the prayer for adjournment is allowed. Let this matter, it will go to the month of, in the month of August.
Maybe in July after vacation or immediately after.
July also. Let this matter be listed on 14th July.
Grateful.
Yes. This is item number
18.
Yes.
I was submitting earlier, Your Lordship, that the basis of ascertaining the loss of earning capacity, that is the medical evidence on record, that is the physical disability which is ascertained by the doctor, and its impact on the income and avocation of on the injured. So until the income and avocation that has not been ascertained, how could have the learned tribunal below ascertain the loss of earning capacity at 100%?
Okay.
So first, I'd like to show your lordship the definition of permanent partial disablement, which will be there in the Employees Compensation Act.
Employees Compensation Act. Adhiraj Misra. You read slowly.
Yes. 21G.
21G.
Yes, of the Employees Compensation. It defines partial disablement. Now, partial disablement means where the disablement is of a temporary nature, such disablement as reduces the earning capacity of an employee in any employment. This word is important, in any employment in which he was engaged at the time of the accident, resulting in the disablement. And where the disablement is of a permanent nature. Now comes the permanent nature, partial permanent disablement, such disablement as.
But this definition is for the purpose of assessment of compensation in employees' compensation.
But there is one decision passed by the apex court. The court has discussed that we can refer to the Employees Compensation Act also. Because the definition of permanent partial, your lordship will not find in the MB Act directly. The decision I was referring to is 2011 1 SCC 343. Rajkumar versus Ajay Kumar.
1 SCC.
2011 1 SCC 343.
Para?
Relevant paras will be, there are a lot of paras. I'll read the.
Which one you are relying?
I'll rely upon 10, 10, 11, 12, 13.
For what purpose you are relying?
The point that what is the procedure which is to be followed by the tribunal on for ascertaining the earning capacity of the injured.
Yes.
So first I'll read this definition once.
Okay, read.
21G, where the disablement is of a permanent nature,
such disablement as reduces his earning capacity in every employment, again every employment, which he was capable of undertaking at that time. So what has been meant by this definition, that in order to come within the purview of this permanent partial disability, the disability, the earning capacity has to be reduced not only in the current employment at the time of the accident, but every other employment which the injured was capable of undertaking. So in the present case, the very employment only has not been ascertained. Now I'll come to this judgment. I'll come to para 10. Where the claimant, it starts with where the claimant suffers a permanent disability.
Yes.
Where the claimant suffers a permanent disability as a result of injuries, the assessment of compensation under the head of loss of future earning would depend upon the effect and impact of such permanent disability on his earning capacity. A tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss or loss of earning capacity. In most of the cases, the percentage of economic loss, that is the percentage of loss of earning capacity, this will not be much important. The next para then, 11. What requires to be assessed by the tribunal is the effect of the permanent disability on the earning capacity of the injured. And after assessing the loss of earning capacity in terms of a percentage of the income, it has to be quantified in terms of money to arrive at the future loss of earning. Now, next para, 12. Therefore, the tribunal has to first decide whether there is any permanent disability. First of all, that has to be ascertained by the tribunal. And if so, the extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence on record. Whether the disablement is permanent or temporary, that has to be ascertained first. If the disablement is permanent, whether it is permanent total or permanent partial disablement. Now 3, if the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on the functioning of the entire body, that is the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of earning capacity. But if the tribunal concludes that there is permanent disability, then it will proceed to ascertain its extent. After the tribunal ascertains the actual extent of permanent disability of the claimant based on the medical evidence, it has to determine whether such permanent disability has affected or will affect his earning capacity. Ascertainment of the effect of permanent disability on the actual earning capacity involves 3 steps. The tribunal has to first ascertain what activities the claimant could carry on in spite of the permanent disability and what he could not do as a result of the permanent disability. This is also relevant for awarding compensation under the head of loss of amenities. The second step is to ascertain his avocation. This is important. Avocation, profession, and nature of work before the accident, as also his age. The third step is to find out whether the claimant is totally disabled from earning any kind of livelihood, or whether in spite of permanent disability, the claimant could still have effectively carried on the activities and functions which he was earlier carrying.
How much compensation was granted in this case?
20 lakhs with interest. Yes. So I'm only on the, your lordship may come to page 11, the award which has been calculated. I'm only on the loss of earning capacity.
the second head. 5,000 into 12 into 18, which amounts to 10,80,000, 10,80,000. So here what the tribunal has done has assessed the entire loss of earning capacity at 100%, which shouldn't have been based on the medical evidence on record. So that is only my precise case.
Yes, Mr.
Oh, my lord, in this regard, I have to go again the judgment which was passed by the tribunal. Nashid law will find, my lord, my learned friend already read, my lord, issue number 3 and 4. So I would like to read my issue number 3 again. Because, my lord, the whole case is on the basis of the evidence of the doctors. Doctor, my lord, this is the AK Dalaguppa, the PW4, and a report which was your lordship in filed in the, my lord, the TCR in my lord, the page number I have marked, my lord. So on the basis of the report, my lord, this disability, my lord, the physical disability, my lord, regarding my lord, my lord, the board, my lord, it was assessed as 10%. And so far, my lord, lordship already pointed out, my lord, the IQ, my lord, which was assessed, my lord, 60. And his normal lordship will find in the TCR, my lord, this red mark of my lord. And that report was not challenged by my learned friend. It is already mentioned in the my lord, the judgment also.
It is exhibit 19.
19 lordship. The last part, my lord, will find. Is the board decision, my lord.
It says that in view of IQ indicating IQ, what it says?
Intellectual question. IQ. It is
IQ.
mentioned.
He requires further assessment and evaluation by neurologist and neurosurgeon.
That is
there is no final assessment.
No final assessment, but whatever my lord, assessment come from this report, my lord, it is assessed, my lord, 10% of the physical disability, and his IQ is 60, whereas his normal was, my lord, it is mentioned in the lordship 90 to 110. So he was a normal person, my lord. Due to this accident, my lord, his IQ reduced to, my lord, 60.
Where it is mentioned 90 to 110.
My lord, may kindly see issue number 3 and 4. In page, lordship will find 10, page 10, my lord. Therefore, in absence of any counter from the opposite party, number 2, it can be taken as a substantive proof of the fact that the victim was having an average IQ ranging between 90 to 110. This shows that the accident has caused serious impairment in its intellectual.
Where is the evidence that he was having average IQ before accident?
Madam, that was the report. From the report, it is.
But where is in report it is not mentioned that what IQ he was having before accident.
So it is evidence from the doctor, my lord. Dr. PW4.
No, it only mentions that when the injured was examined by the doctor, his IQ was found to be 60.
Lordship.
But what was his IQ earlier?
My lord, it can be, it is presumption here, my lord, IQ ranging from between 90 to 110. Or I have not seen the full report, my lord, completely. Is there any mention here, my lord? It is exhibit 19, my lord.
How it is 100% functional disability?
So, my lord, I have done some judgment, my lord, the apex court, my lord. If, my lord, it is 60, my lord, IQ, then it's, my lord, as per the judgment, my lord, is amount to, my lord, it is called mild, my lord. This, my lord, very recent judgment, my lord, it is, this judgment also Rajkumar also discussed here, my lord. Just a minute.
Where?
This is reportable, my lord, 2026.
No, what you want to say?
My lord, if IQ of 60, then it's amount to permanent disability.
Which para? Which para?
Lordship will find, my lord, in this case, my lord, the similarly, my lord, tribunal was, my lord, awarded, my lord. That was challenged before the, my lord, High Court. High Court reduced the, my lord, award, and thereafter, my lord, traveled to the Supreme Court, and Supreme Court, my lord, finally, my lord, it is enhanced, my lord. So Lordship will find, first para 4.
No, where is the final assessment by Supreme Court?
Oh, final, my lord, Lordship will find 27, my lord, 27, 29, 30, 31. It is also mentioned, my lord, regarding IQ, my lord.
Where is that paragraph?
Lordship will find 16, my lord. My lord, my God. Para 16, my lord.
Para 16 is only
Yes, my lord.
Submissions.
Categorized, yes, A, thereafter B. In B, my lord, it is mentioned IQ score of 65 plus him within the category of the mild intellectual disability. Thereby evidencing substantial neurological derogation having direct bearing on his functional abilities and employability. So accordingly, Lordship will find my lord, may para 25 also है. It is mentioned.
Yes.
My lord. In order to determine the functional disability suffered by the affiliate claimant, it is necessary to avoid the finding recorded by medical board with respect of permanent physical disability as well as neurological assessment report placed on record. Both these documents remain uncontroverted and hence they provide credible expert evidence so as to assess the extent and nature of disability. The true nature and the extent of the injuries and their impact on the cognitive and the functional abilities of the appellant claimant can be properly appreciated only upon a careful consideration of these materials. For ready reference, the relevant extract from the said documents are reproduced. So, my lord, there are some document also that, my lord, next 26, my lord. Para.
In the instant case, who are the board members? There were 3 doctors.
Yes, my lord.
Whether any neurosurgeon was there out
My
of those 3?
My lord, the signature is there, my lord, in the 19, my lord. Exhibit 19.
Whether any neurosurgeon was there, because there was a recommendation that the claimant should be further assessed by neurosurgeons.
But as per my judgment, my lord, doctor, he was the one doctor. My lord, issue number 3 and 4, my lord. The claimant witness number 4, Dr. A.K. Dalgopo, the professor and head of the Department of the Orthopedics in the Silchar Medical College Hospital and also the chairman of the Special Medical Board constituted for assessment of the nature and extent of the injuries and the disablement suffered by the victim Zakir Hussain Talukdar has deposed in his testimony that on examination by the medical board, the right lower limb of the victim has found 2 centimeters short, causing permanent physical disablement of 10%. He has also deposed that 2 of the teeth of the victim were also found missing, and that because of the head injuries suffered by him, he has suffered intellectual impairment, reducing his intelligence quotient to 60, and that he requires further assessment and evaluation by neurologist and neurosurgeon.
Yes,
So
this
that-
assessment was not done.
This was not done. I also checked, my lord, this was further not done.
What is your submission?
Now my submission is that, my lord, so far I place the judgment, my lord. As per this judgment, my lord, if it is, my lord, the IQ is 60 or 65, my lord, and it is Honorable Supreme Court also considered, my lord, and considering that factor, my lord, the award which was granted, my lord, and thereafter High Court, my lord, reduced, my lord, but Supreme Court, my lord, assessed, my lord, and finally Lordship will find, Lordship may kindly see 30, my lord, para 30.
No, but the case which you are referring, there was an assessment by medical board and separate neurological assessment. In the case which was before Supreme Court. But in this case, in spite of recommendation that he requires further assessment and evaluation by neurologists, same was not done.
Yes, my lord. But so far, my lord, IQ 60, that report, my lord, has not challenged, my lord. That's remained, my lord, unrepeated, my lord. And this tribunal also, my lord, while passing the order, my lord, look into it, my lord. And if that be so, my lord, the person who, my lord, already, my lord, IQ of that, my lord, is maybe, my lord, more than that, my lord. And so far, my lord, IQ 60, my lord, I have seen, my lord, the person, my lord, cannot, my lord, do work properly, my lord. My lord, I have also talked with my client, my lord, this victim, my lord. He can speak, my lord, after some time, my lord. When I ask something, he speak. So, my lord, this cause disablement, my lord. And so far, my lord, the income, my lord, he was a businessman, my lord. His earning was 15,000. But, my lord, tribunal assessed, my lord, his...
Where is the evidence that he was a businessman?
My lord, his mother evidence, my lord.
Okay,
Evidence,
okay.
Roshi will find in evidence.
No, no. How, on what basis tribunal assess that the functional disability is to the extent of 100%?
My lord, from the, my lord, yes, my lord, this which was passed, Lordship may kindly see again, my lord. This, my lord, issue number 3 and 4. May I read again, my lord? Last part, my lord. It can safely presume that a person of IQ of 60 cannot be employed in any employment. The loss of earning capacity of the victim has...
What is the basis of this presumption?
Because of my injury suffered. And there are many more injury report is there. My lord, GNRC injury report is also there. Let's see, we'll find in my lord TCR at page, my lord, that page was not given. Page 1F, it is written, GNRC head injury report.
Okay. Any others?
So, my lord, there are more judgment, my lord, in this regard, my lord. But so far, my lord,
No, when the apex court has held in the case which is relied upon by you,
Lordship,
that IQ score of 65
yes,
will place the person in the category of mild intellectual disability. Disability is mild.
mild, yes.
Then if IQ is decreased by 5 points to 60, how it becomes 100% disabled?
My lord. My lord, in this judgment also discussed, my lord, this IQ of 65. Lordship will, para 29.
No, I have gone through that.
My
It
lord,
says
last
that,
65.
it says that you listen to my query. It says that where there is an IQ of 65%, that person may be presumed to be in category of mild intellectual disability.
Lordship.
Disability is there, but
Yes,
that
yes.
is mild.
Yes.
But the tribunal has regarded him as resulting into 100% functional disability.
My lord, in the judgment it is mentioned mild.
Okay, what else is?
Last part, my lord. This is my lord. Regarding the fact of the present case, the appellant claim was admittedly employed as a manager in a private concern, a rule inherently dependent upon sustained causative functioning, including memory, retention, analytical ability, excessive decision making, coordination, and effective communication. The neurological report on record evidences severe impairment in verbal and visual memory, frontal lobe disaffection, and an IQ score of 65, placing him with category of mild intellectual disability. So, my lord, I have in Google, I have to check, my lord, some category-wise list is given, my lord, and this IQ is 62, my lord, 100. It's
average, below average.
My lord, this is 55 to 69, mild mental disability. And above, my lord, this is 70 to 84, borderline mental disability, 85 to 114, average intelligence, and more than that, my lord, he is bright. So, if it is 60, my lord, then it will come on.
So a person with mild mental disability cannot do any kind of work.
Man, that is not exactly, but he
If
cannot.
that is not exactly, then 100% for functional disability may not be there.
But in this case, my lord, Supreme Court, that was a 60% of disability, my lord. And later on, my lord, so far functional disability is counted, my lord, it is found 65. And 65 counted as, my lord, per 100%. So, my lord, so far, my latest judgment, my lord. And finally, my lord, Supreme Court also, my lord, enhanced the, my lord. And so far, my lord, remanding back, my lord, Supreme Court also stated, my lord, since it is matter of old, my lord, so without, my lord, remanding them back the matter, my lord, Supreme Court, my lord, itself taken the matter, my lord, on evidence on record. Para 31.
Okay.
Para 31.
Okay.
Was.
Yes. What else is your suggestion?
So humble prayer is, my lord, since, my lord, the tribunal, after going for the, my lord, all evidence on record, my lord, passed the judgment, my lord, and also in evidence, but, my lord, so far income, my lord, tribunal, my lord, assess minimum wages rate, my lord. I have seen in Supreme Court also, my lord, when there is no, my lord, evidence, my lord, as a proof, my lord, still it should be, my lord, minimum wages rate, my lord. And tribunal has rightly, my lord.
Heard Mr. S. Datta, learned counsel for the appellant. Also heard Mr. G. Uddin, learned counsel for respondent number?
1.
Respondent number 1. This appeal under section 173 of the Motor Vehicle Act 1988 has been preferred by the appellant insurance company, namely Oriental in India, Oriental Insurance Company Limited, under Section 173 of the Motor Vehicles Act, impugning the judgment and award dated 16/6/2017, passed by the learned district judge, member, Motor Accident Claims Tribunal, Karimganj, in MEC case number 93/2018. The facts relevant for consideration of the instant appeal, in brief, are that on 18/2/2011 at about 9:30 p.m. when the present respondent number
Here the respondent one is the father of the injured.
okay, when the son of the present respondent number 1, namely Zakir Hussain Talukdar, was driving a motorcycle a truck bearing registration number AS 103439, driven in a rash and negligent manner. How the accident occurred? Rash and negligent manner.
The truck had
Dashed against the motorcycle, causing an accident wherein the son of the present respondent sustained grievous injuries on his person. Stop. Thereafter, stop. After the said accident, the father of the injured person, Zakir Hussain Talukdar, namely the present respondent number 1, had approached the Motor Accident Claims Tribunal, Karimganj, by filing an application under Section 166 of the Motor Vehicle Act, claiming compensation for the injuries sustained by his son in the above-mentioned vehicular accident. The aforesaid claim case was registered as MSC case number 93/2011. You did not contest.
No, I did not produce any witness.
Whether you filed a written statement.
Yes, we filed a written statement.
The present appellant as well as owner of the way, present appellant contested the claim by filing written statement, taking various defenses, including the defense that the offending truck was not covered under valid insurance policy. Stop. The owner of the offending vehicle did not appear before the tribunal and the claims proceeding proceeded ex parte against the said owner. On the basis of the pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Quote A from page 7. In support of his claim, the father of the victim examined 2 witnesses and exhibited several documents. How many witnesses we have? 2 or 4?
4 would be, my lord. Three, my lord.
I think 4 witnesses.
4 is the doctor, my lord. PW 4 is doctor.
Examined 4 witnesses. The insurance company did not examine any witness in support of their defense. Ultimately, by the judgment and award dated 16/6/2017, which has been impugned in this appeal, a compensation amount of rupees 20 lakhs along with an interest at the rate of 6% per annum was awarded to the claimant. Stop. Mr. S. Datta, the learned counsel for the appellant insurance company, has submitted that this appeal is mainly directed against the impugned judgment in as much as the trial court, in as much as the Motor Accident Claims Tribunal erred in assessing the loss of earning capacity of the injured without taking into consideration the injury report as well as laid down principles in this regard by the apex court. He submits that though the doctor who had examined who had who has been examined as witness number 4 and who was one of the member of the medical board which assessed the disability of the injured victim, has categorically found that the physical disablement of the victim within bracket son of the claimant bracket close was only to the extent of 10% as his right lower limb was found to be 2 centimeters short, causing permanent physical disablement. However, the tribunal assessed the functional disability to the extent of 100%. He further submits that the medical board, which examined the injured, had also opined that the injured suffered intellectual impairment, reducing the intelligence quotient to 60. However, it failed to take into consideration that the medical board has recommended further assessment and evaluation of the injured by neurologist and neurosurgeon. So, learned counsel for the appellant submits that the tribunal, without directing an assessment regarding intellectual impairment of the victim by neurologist and neurosurgeon, as was recommended by the medical board, had itself assessed the loss of functional loss of earning capacity at 100% without taking aid of the any medical without taking aid of any expert opinion from any qualified neurosurgeon or neurologist. Stop. He submits, learned counsel for the appellant further submits that the victim, the injured victim, has failed to reduce any evidence to show that he was actually and gainfully employed before the accident, and an observation to that effect was also made by the tribunal in the impugned judgment. However, in spite of that, it came to a finding that loss of future earning capacity of the victim is to the extent of 100%. Stop. Learned counsel for the appellant submits that the tribunal was wrong in arriving at such a decision. He submits that the permanent disability whether it is functional, whether it is physical or intellectual, is to be ascertained only on the basis of medical evidence. And after ascertaining permanent disability, the tribunal has to assess actual loss of actual earning capacity, and for that the apex court in the case of Rajkumar versus Ajay Kumar and another reported in 2011 1 SCC 343 has laid down a formula involving 3 steps. He submits that the tribunal has to first ascertain what activities the claimant could carry on in spite of the permanent disability and what he could not do as a result of such a disability. The second step is to ascertain his evocation, profession, and nature of work he was engaged before the accident, as also his age. And the third step is to find out whether the claimant is totally disabled from earning any kind of livelihood, or whether in spite of permanent disability, the claimant could still effectively carry on activities and function which he was carrying on earlier, or he could carry out some other work or some or lesser scale of activities or function so as to continue to earn or can continue to earn his livelihood. Learned counsel for the appellant submits that in the instant case, the tribunal, without asking for a report, a assessment report on the intellectual impairment of the injured from neurologist and neurosurgeon, on its own presumed that the injured victim is unable to perform any kind of work, thereby loss of his earning capacity was assessed at 100%. He submits that this is a fit case for remand of the case back to the tribunal or with a direction to subject the injured victim, to medical examination by neurologist and neurosurgeon for assessing the actual intellectual impairment and his intelligence quotient. Stop. On the other hand, Mr. G. Uddin, learned counsel for the claimant respondent, has submitted that the tribunal has correctly granted compensation to the son of the present respondent number 1 for the injuries sustained by him in the motor vehicular accident. He also submits that the tribunal has correctly assessed the loss of earning capacity at 100%. He submits that though the physical disability of the injured victim was assessed, physical permanent disability of the injured victim was assessed at 10% due to shortage of his right limb by 2 centimeters. However, the tribunal had not only taken into consideration the physical disability, but also the intellectual impairment caused to him due to injuries sustained by him on head injuries were there
Issue number 1 and 2.
on his head.
Loss of
He submits that
that
the intelligent quotient of the applicant of the injured victim was found to be 60, which is much below the intelligent quotient of 90 to 150, which should be there for a normal person. He submits that the tribunal had correctly arrived at a conclusion that due to impairment of intellectual capacity and due to reduction of the intelligence quotient to 60, the injured victim was not in a position to perform any kind of work, and therefore the loss of his earning capacity was assessed at 100. In support of his submission, learned counsel for the respondent has cited a ruling of the apex court in the case of R. Halle, HALLE versus Reliance General Insurance Company Limited, reported in 2026 INSA 260. He submits that in the said case, the intelligent quotient of the injured victim was found to be 65, which is more than the intelligence quotient of the present injured victim. However, the apex court held that a person with intelligent quotient 65 may be placed within the category of mild intellectual disability, and thereafter it assess the functional disability to at 100%. As due to loss of as due to impairment of intellectual capacity, the victim was not in a position to perform any kind of work. Stop. Learned counsel for the respondent further submits that since the accident in question took place way back in the year 2011 and already 16 years have lapsed, the ends of justice may not be served by remanding the case back. He therefore submits that there is no infirmity in the impugned judgment and the appeal is liable to be dismissed. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the records of the MSc case. MSc case number 93/2020-11, which was a requisition from the Concerned Motor Accident Claims Tribunal. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. ... I'm keeping in the judgment reserved. Yes.
Obliged.
Quick.
Litigant-in two.
You're ready?
Yes. Lordship, for this petition, Lordship, I've taken 3 grounds. I was submitting on violation of Article 22, Clause 2, Lordship, whereby the Lordship goes by the FIR. The chronology is that around 6:55 a.m. they have got the information, and at 7:20 a.m. they have from the place of occurrence. First, the petitioners and the contrabands were seized, and accordingly, both the petitioners were apprehended before taking them to Gauhati GRPS police station, Lordship. Lordship, after that, Lordship, the medical prescriptions and reports, which are on page 55 and page 56, Lordship. I have submitted earlier that this the time and date, which is the date of the forwarding, as mentioned in the medical report, and the time is 11 a.m., which would be which is before the production, which has been made before the production, and that is reflected through the order dated 3/4/2025, which is on page 37, Lordship. Page 37, Lordship.
Yes, what is there in front?
Lordship, on second para, Lordship.
Yes.
Seen the forwarding report, arrest memorandum, notice, inspection memos, and medical reports produced before me. The accused have been made aware of their legal rights. The accused has also stated that they are not suffering from any injury inflicted by police. Now I am relying upon the Supreme Court judgment which I have submitted, Lordship, on Subhas Kumar, Lordship. As
Where is the Supreme Court judgment?
Lordship, there itself, Lordship. And one of the Lordship own order, Lordship, in Subhas Kumar versus Directorate of Enforcement, Lordship. On page 3, Lordship. More specifically from para 6, Lordship, where the physical custody was considered, Lordship.
Subhash Kumar blocks. Supreme Court. Subhash Sharma.
Subhash Sharma, sorry. Lord. Subhash Sharma, Lord. Para 6, Lordship. It continues on page 3. The relevant part.
Let's read.
Lordship, on page 3, Lordship, the finding of the fact recorded in paragraph 10 is that undisputedly the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 1100 hours on 5th March 2022. Thereafter,
Yes, there is undisputed fact, finding as to fact in this case. In your case, when your custody was taken?
immediately after the seizure was made, Lordship.
What is the time?
Seizure time is that, Lordship.
After the seizure, after how much after the seizure?
Lordship, at the time of the seizure itself, Lordship, because if the seizure is made, the petitioner physical custody will be within the police personnel itself.
No,
Lordship.
not necessary.
Commercial quantity of contraband has been seized.
It is not necessary. It is the arrest memo shows that you were arrested on at 8 p.m.
8 p.m. and in the police station, Lordship. And moreover, Lordship, he is not in the police station at the earlier procedure. The seizure procedure is going on, Lordship.
Yes, Lordship. And
seizure procedure is
there
going
itself my physical custody, because in the FIR itself, it has been stated in the last para on page 25.
What time FIR was registered?
13 at the time of registration of FIR is 13:38 hours.
1:38.
1:38. And on the last para of the FIR, it is mentioned thereafter all the seized the article along with 2 apprehended person.
So you have to be apprehended before 1:38. It may be 1:37 also.
Once contraband has been seized, which has been seized at the time of.
No, it means that you were apprehended before 1:38, before registration of FIR.
Yes, Lordship, during when the seizure was made, as it has been mentioned in the FIR that all seized article along with 2 apprehended person will brought to GRPS. That means they were apprehended before bringing to GRPS at the place of occurrence itself. Before bringing to GRPS, and after coming to GRPS, they have the FIR has been lost, and subsequently other procedure were laid down. Lordship, in one of the case, coordinate bench, Lordship, BA number, Lordship, 3795. I have submitted, Lordship.
What it says?
Para 9, Lordship, the records before the court revealed that the petitioner has been actually taken into custody at least prior to the search party leaving the place of occurrence and arriving at the police station. Therefore, the petitioner had been taken into custody on 17/6/2025 prior to 2 o'clock. There has been no specific reference in the record.
FIR may be different, Lordship.
Then FIR is different.
No, what is your submission? In the instant case, at what time you were apprehended?
In the instant case, Lordship, the time of seizure may be considered.
I'm not asking time of seizure. Repeatedly, I'm asking what is you know when you were apprehended. It is only you have not raised that issue on earlier 3 occasions. Now you have come up. Now, what is your contention? At what time you were arrested? What time you were apprehended? Though it appears that you were apprehended before 1:38 p.m. because at 1:38 FIR was registered.
My
Suppose if we take it as 1:38, then
Lordship,
at what time you were produced?
the production time is not mentioned in the production order. That production time is not there. Time of the production is not there. Date of the production is there.
Date is
3
on the next date.
Yes, next.
Suppose you are produced at 10 a.m., then there is no violation.
Yes, if I am produced at 10 a.m., but I am not been produced at 10 a.m.
So at what time you were produced?
After the medicals were conducted, because the medical record is there, and medical has been seen by the Garnet board below.
Medical was conducted at
11.
11:59. Still, it is before 1:38.
Still, it is before 1:38. But my submission is that once the seizure has been made, my physical custody my physical custody has been taken by the police personnel. Without my physical custody, the seizure cannot be made. And if a seizure is made, I have been apprehended. I have been taken into custody.
What is the contraband?
It's cannabis lodging, ganja lodging.
Much.
24.4.
There are 2 seizure lists, lordship, separate seizure list. One on page 28, which is from the petitioner number 1, 11 kg 150 gram, and page 29 from petitioner number 2, 13 kg 180 gram.
So it is 24.25 kg.
Yes, what else is your submission? Anything else? Other 2 points.
Other 2 grounds, lordship, I have. Lordship may come to page 57, lordship. Arrest memo, lordship. There's a violation of section 36 of BNSS, lordship, and section 62, lordship, as there is no attesting independent witness, lordship. As regarding to, I'm relying on DK Basu's judgment and one of the coordinate bench observation made with regards to the DK Basu.
But in such cases, lordship, if 48 is given, that also lordship consider earlier occasions, lordship. In 48, in that case, because in the same time 48 is also given.
Okay.
48 is separate, lordship, and arrest memo is a separate procedure. It has to be made when the person has been detained or arrested, lordship, then and there. That is what DK Basu says, lordship.
Thereafter, third ground.
Third ground is, lordship, not serving of 48 notice, lordship.
48 was not served.
Found, lordship, in the scan copy, but it may have been. It cannot be stated that it has not been there, lordship.
Not served.
But it is not, I have not found. And nothing is stated about 48, lordship.
In the petition.
No, in the petition also not stated.
It is stated, lordship.
In the scan copy, I have not found, lordship. 47 I have found.
Okay, what is your submission now?
In my submission, lordship, very well known, in my humbly, I want to submit that, lordship, 24 hours is given to the investigating officer. Within 24 hours, case may be completed also, lordship. So, in this case, if I look into the FIR, nothing is there that they have apprehended before this 8 p.m. Because from the records, what I have seen, lordship, arrest memo, it was clearly stated that he was arrested on 8 p.m. at the police station, lordship. He was brought to the police station and he was arrested. And before that period, lordship, the seizure procedure was going on, lordship. So in my humbly, I want to state that it is not arrested on 8 p.m. also only, as it is stated in the arrest memo. And secondly, lordship, during this 48, regarding his 48 statement, lordship, what I need to know, Lordship, whether 48 statement, section 48 has been served to him or not. If it is served, then in some cases I have seen, Lordship, in many court has stated that, Lordship, it though it is there that it is signature has to be given, but the motto of section 36 arrest memo of say having signature of the attested one of the person, Lordship, is to inform. And if it is informed at the same time, Lordship, through 48, so it can be taken into account, Lordship. But in the case diary, in the scan copy, I have not found, Lordship.
Then
But I cannot state that whether it has been served or not, Lordship. There is no, because in the production order, Lordship, their notices are
scan copy of CD is there.
Lordship, I have not found, but whether it is complete or no, I am not afraid, Lordship.
Actually, in regards with to the date and time of the arrest, which is mentioned in the arrest memo, there is a mere formal procedure. Even the Supreme Court has.
But in all cases, it is not, Lordship. It is all cases, it is not. He has to prove that it is a formally made formally.
The mere formal procedure as the physical custody has to be counted, Lordship. That is what the Subhash Sharma case says. And in arrest memo, Lordship, there is a witness is there, but the witness is a police personnel.
Moreover, Lordship, I humbly want to state that Lordship, in other cases, I am not stating about that 48 this 24 hours, Lordship. But in such cases of NDPS cases, time needs, Lordship, because many procedures are there. Police need some time before arrest, Lordship. These procedures are there. I want to submit on that, Lordship.
Yes.
Lordship, procedures are needed in NDPS cases before arresting a person, Lordship, because they have to give positive test or not. Their kit is also there, Lordship. Then these procedures are also there. Malkhana have to be given their, Lordship. In other cases, no such formalities are there, Lordship.
Okay, may I submit further on 36 violation, Lordship?
Yes.
Actually, I am referring to DK Basu's case and Lordship. DA number 866, Lordship. My submission is that, Lordship, there is a witness who is a police personnel, and even the Sanhita says that section 36B, attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest has been made. That is what DK Basu said, and upheld by Honorable Coordinate Bench, Lordship, of Gauhati High Court, Lordship, in DA number 866.
Okay, heard Mr. D. Medhi, learned counsel for the petitioner, also Mr. K. K. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely number 1 Sezo Puro, number 2 Boylen Haukip, who are detained behind the bars since when?
Since 2/4/25, Lordship.
Since 2/4/2025, in connection with charge sheet has already been filed.
Yes, Lordship.
And charge has been already framed,
One
and one of the witnesses
one
also
witness is
been
examined.
In connection with NDPS case number 177/2025, arising out of GRPS case or Gauhati GRPS case number 44/2025 under section 20B2C/29 of the NDPS Act 1985. It is pertinent to mention herein that on earlier occasion also the petitioners had approached this court by filing application for bail. However, their prayer for bail was rejected after going through the materials on record. The gist of accusation in this case is quote para 3 from page 62. So, learned counsel for the petitioners has submitted that though total 24.25 kgs of ganja were seized from the petitioners. However, same was seized separately, and two separate seizure memo were prepared. In one case, only 11.150 kg of ganja was seized, and remaining ganja was seized by the other accused person. Stop. Learned counsel for the petitioners has submitted that this time the petitioners have approached this court seeking bail on the ground of violation of their fundamental rights guaranteed to them under under Article 22 and 21 of the Constitution of India, as well as for violation of provisions of Section 36 and 48 of BNSS. Learned counsel for the petitioner has submitted that in the instant case, the information regarding commission of the alleged offense was received by police at 7:20 a.m. on 2/4/2025, and thereafter, during search of the 12423 down Rajdhani Express, the said contraband was recovered from both the petitioners. He further submits that the recovery as well as seizure of the contraband was made from petitioner number 1 at 8:27 a.m. on 2/4/2025, whereas the seizure from the second petitioner was made on the same day at 9:05 a.m. He further submits that in the instant case, the FIR was registered at 13:38 hours on 2/4/2025, and the fact of apprehension of the present petitioners by police has been disclosed in the FIR itself as stop. It is categorically stated in the FIR that after preparation of the seizure list, it is categorically stated in the FIR that the contraband was seized from the possession of the present petitioners after they were apprehended. However, in the arrest memo, date of the time of the arrest has been reflected as, what is the time?
8 p.m.
8 p.m. He further submits that the actual physical apprehension of the petitioners, the time of actual physical apprehension of the petitioner has to be taken into consideration for computation of period of 24 hours under Article 22 within bracket 1 of the Constitution of India. He submits that it is clear from the medical examination report annexed along with the forwarding report of the present petitioners that they were produced for medical examination at Dhirenpara FRU on 3/4/2025 at 11:59 a.m. Hence, he submits that
10:59, Lord.
huh?
10:59.
10:59 a.m.
Petitioner number 1 and petitioner number 211.
Your main basis is this medical report. After 10:59, you were produced. And your arrest,
Time of seizure, Lord.
you are saying time of seizure, he is saying before filing of the, before 1:38.
A physical custody has been taken. That is what I have been submitting.
Stop. Last line, Kelly. Since he submits that undisputedly the physical custody of the petitioners was taken over by the police at the time of recovery of contraband from them before seizing the seizure of the contraband. And therefore, they ought to have been produced before the trial court, before the magistrate, within 24 hours of their actual apprehension. He submits that by showing a later time in the arrest memo, the arresting authority cannot be absolved from the responsibility of production of the arrested persons before the magistrate in terms with the provision of Article 22 within bracket 1 of the Constitution of India. He submits that any violation of Clause 2 of Article 22 of the Constitution of India would render the arrest as illegal, and on that count itself, the petitioners are entitled to get bail. In support of his submission, learned counsel for the respondents has cited ruling of the apex court in the case of Directorate of Enforcement versus Subhash Sharma within bracket 2025 INSC 141. He further submits that there has been a violation of the provision of section 36 of the BNSS in the instant case, as no signatures of any independent witness was obtained on the arrest memo after the arrest of the, where is the arrest memo?
Lordship, on page 57, Lordship.
Arrest memo
Page 57, 58, 59, and 60.
after the arrest of the present petitioners. He submits that this itself amounts to violation of guidelines of the apex court issued in the case of D.K. Basu versus State of West Bengal, reported in AN 1997 AC 610. He also submits that there has also been violation of mandate of section 48 in as much as 47 has been followed. 48 in as much as no written communication of the grounds of arrest were made to the relatives / friends / nominated person of the accused persons in this case. He therefore submits that the constitutional mandate of Article 22 and Article 21 of the Constitution has been violated in this case, and on that ground, the petitioners are entitled to get bail. Stop. On the other hand, Mr. K.K. Das, learned counsel for the learned additional public prosecutor, has vehemently opposed the grant of bail to the present petitioners. He submits that the quantity of contraband seized in this case is commercial quantity, and said aspect has been taken into consideration by this court while rejecting the prayer for bail of the petitioners on earlier occasion. He also submits that, as such, the embargo of Section 37 of the NDPS Act is applicable in the instant case, and therefore the petitioners may not be granted bail in this case. He also submits that the arrest memo clearly indicates that the petitioners were arrested at 8 p.m. on 2/4/2025, and therefore,
Moreover, let's say it was registered on 1338. It has been registered, the case has been registered on lots of FIR.
when
1338 hours.
Oh, yes.
Lots of.
8
And
p.m.
there is nothing in the.
He also submits that though the FIR indicates that the petitioners were apprehended, however, the FIR was registered at 1338 hours on 2/4/2024-25, and there is nothing on record to indicate that the petitioners were produced before the court after 1338 hours on 3/4/2025.
No, I want to state here.
After 1338 on next day,
No, but
on 3/4/2025, he further submits that since the case involves commercial quantity of contraband, the procedure to complete formalities of seizure and other mandatory procedure takes considerable time, and the petitioners were therefore not arrested during conduct of the said procedure.
24 hours journey time has to be also excluded.
Stop. He also submits that the law provides that journey time for from the place of arrest to the nearest magistrate has to be excluded while computing the period of 24 hours. In this case, he submits that in this case, the petitioners have failed to show that they were produced before the magistrate after 24 hours of their arrest, and therefore he submits that there is no violation of the mandate of Article 22 within bracket 2 of the Constitution of India.
Moreover, Lordship, there are two other one point only, last point, Lordship. They are from Nagaland and Manipur, Lordship. These 2 persons.
He also submits that the petitioners, having been involved in offense involving commercial quantity of contraband, may not be released by taking into consideration that they are inhabitant of Nagaland and state of Nagaland and Manipur, and if they are released, their attendance may not be easily procured. He however fairly submits that after going through the scanned copy of the trial court records, he could not find the notice under section 48 of BNSS. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the scanned copy of the trial court records. Today is 14.
Next 14.
19. On 19, I will deliver.
Along with the DK Basu Lordship, I am also referring to a coordinate bench order bail application 6/26 that may be.
You take back the judgments which you have given. Mark the paragraphs which you are relying. Adhiraj. Mark the paragraph and point for which you are relying on them. Marking Kori written. Heard so and so. Let this matter be listed for delivery of orders on 19th May.
Standing item 17.
Made this Lordship.
The amputation case, amputation through shoulder lordship. Main ground of appeal.
You are appellant
Appellant lordship.
for enhancement.
Lordship. The income considered on the lower side, only 5,000. You are the driver of heavy vehicle. Only monthly income considered as 5,000 lordship.
What was the evidence on record?
Evidence lordship, driving license has been exhibited, and moreover,
No, driving license is not the evidence of
uh,
evidence of income.
income is not there, but occupation is there. Lordship,
How will we assess the
Lordship, the claimant.
Suppose you have a driving license,
Lordship,
but you don't drive the vehicle.
Lordship, CW1 court witness
Yes.
stated that you are the driver by profession.
No, there is no dispute.
And Lordship, moreover, CW3, that is IO.
No, just a minute. CW1 says you are a driver.
Lordship.
And
CW3, the IO, he also stated that during investigation, the claimant stated that he was a driver by profession.
you adduced your own evidence or not?
Lordship, only driving license has been produced, and I stated in my affidavit.
No, whether the claimant was examined as a witness or not.
Lordship.
You did not adduce any evidence regarding your income.
Income. So far, income is occupation is the driver. He is the driver. It is not disputed. And Lanitam also held that. It is not disputed. The other side also not disputed. And in fact, the case proceeded against the insurance company ex parte.
Ex parte? Okay. Now, where the tribunal erred?
So far, income is concerned, considered on the lower side. And
How much income should have been considered?
Lordship, 12,000, we claimant stated 12,000 per month. But there is judgment of Honorable Supreme Court that in case of driver, tourist cab, his income was considered as 10,000. Skilled worker, Lordship. And now moreover, Lordship.
Claimant was examined as CW1.
Lordship, AW1. CW1, 2, and 3, court witness.
Claimant was examined as PW.
PW, Lordship.
PW?
1.
1. He made oral statement that he earns 12,000. Okay.
Lordship, future prospect was not considered. He was below 40 years. So at least 40% should have been added to the income of the claimant. Lordship, no amount has been awarded for pain and suffering. No amount has been awarded for loss of amenities of life and expectation of life. This is a disability, a case of disability, 80%, 85% disability. And so far as future amount awarded for future treatment, only 3 lakhs has been awarded, but we have exhibited estimate for artificial limb. That is more than 5 lakhs.
Okay.
And lordship interest awarded on the side. It should have been 9% per annum.
Anything else?
It's our grounds.
Yes, Mr. Goswami.
And lordship, another point, main point, lordship, I forgot it. 50% has been deducted for personal and living expenses. In injury cases, there should not be any deduction for living and personal expenses.
On what basis you are saying?
Lordship, that is there, the judgment still. 50%. Lordship, can you see?
Where?
Just showing the lordship, can you see at page 16 of memo of appeal? Paragraph 14. 1, 2. Fifth line, lordship. And half of the total income is comes to so and so.
Yes.
So I have some citation, later I will submit it.
You mentioned the paragraph in the citations. Yes. Mr. Goswami.
Because that he was a driver, there is only one that DL was given. No other evidence was there. That's why lordship, member did not consider it as a only certificate was given. Did not that DL was produced, but the certificate from the employer was not given, and it was considered as 5,000 lordship per month. But in that 2011 accident had occurred in 2011 lordship. 2011 lordship 5,000 used to be the 3,000 used to be notional income. Even at times 5,000 for a person who was a skilled worker. That could have been, it was probably considered in that thing. So I have a year lordship. I don't know whether he can be called a skilled worker because that he was a driver was not good. But for unskilled worker, I have a notification lordship. It was 3,900 for unskilled.
But driver cannot be regarded
No,
as
I'm saying he's a driver. There is no evidence that he was a driver.
Okay.
It's a very old, slightly illegible because very old day. The lordship may see 3,900 was the year for wages for unskilled worker. And semi-skilled, it was less than 5,000. And for a very skilled, it was like 6,200. 15 years back, that used to be more or less drivers could be hired for that amount, even if he's a driver. Mere possession of a driving license doesn't make anyone a driver. I agree to the other part of the submission of the 50% ought not to have been deducted. It's an injury case, a deduction for 50% should not have been made. That's why, as per his own evidence, his age was around 39 years. It isn't considered as 26 years. That's why multiplier is accordingly considered as 16. It should be less than. Lordship, may I kindly see the evidence of the must have evidence. It is not of processing history. Evidence of the claimant. It is 39 years actually.
13 years, yes.
It's
40
39 years.
In case of 39 years, 40% should have been added.
But as per judgment, the running member considered as 26 years only. So accordingly, 16 multiplier was in.
This much only.
Others, he said, Lordship, that parents supplying 50,000 has been considered. And for all judgment during that period, that is to be a very good year. Now it has gone up to Lordship because of that kind of thing. Now 50,000 to 1 lakh is considered, but that was allowed. 15,000, 50,000 for those times, it was adequate. Medical expenses have been correctly considered. He has no objection to that. Then lump sum 3 lakhs was awarded future expenses. That takes care of Lordship. In a case of amputation, Lordship, not much is required by of medicines, etc. And that takes care of this prosthetics, limbs, etc. That's the part. Otherwise, there is no reason for giving me. In any case, Lordship, I have a small submission here. For future expenses, even on this 3 lakhs, no interest should be awarded. Something to be incurred in future, interest is not there, because for an expense to be incurred in future, this amount has been already given.
Yes.
On the other part, interest will be applicable. Or at least on future expenses, that interest need not be given. That's my only submission.
Lordship, so far as profession is concerned, he's a driver. There is judgment from Supreme Court. He was a driver of taxi cab, a cruise cab. His income was considered as 10,000.
You give the judgments which you are relying. Heard Mr.
So
M.
in case is concerned, I have also some judgments.
That on future expenses also include.
All I will submit it.
Heard Mr. M. Talukdar, learned counsel for the appellant. So heard Mr. R. Goswami, learned counsel for the respondent insurance company. This appeal under Section 173 of the Motor Vehicles Act 1988 has been filed by the appellant / claimant, impugning the judgment and award dated 26/6/2015, passed by the Motor Accident Claims Tribunal, Karimganj, in MSC case number 54/2011. The appellant is basically aggrieved with the quantum of compensation awarded to him by the claims tribunal. Stop. The facts relevant for consideration of the instant appeal, in brief, are that on 1/3/2011, the appellant was traveling in a night super bus bearing registration number AS 14C 1731 from Karimganj to Gauhati. When the said bus reached Badarpur, it collided with a truck near Shiva temple at Aurangabad, Badarpur. Stop. As the appellant was seated on a window seat, his right arm was severed by the broken window glass. Apart from the said injury, he also sustained other injuries. And later on, other injuries stop. Later on, the appellant had approached the Motor Accident Claims Tribunal, Karimganj, by filing an application under 166 of the MB Act, seeking compensation for the injuries sustained by him in the aforesaid accident. The said case was registered as MEC case number 54/2011. The present though the present insurance company filed a written statement however, later on, it did not pursue with the case, and the case proceeded without its presence. Stop. On the basis of the next para, on the basis of the pleadings of both the parties, the Motor Accident Claims Tribunal framed following issues. Quote A from page.
And your lordship kindly see paragraph 2 at page 12. OP number 2 delayed the proceeding and prayed for several adjournments to find a base, which was finally rejected, and this case completed as well.
ये ऊपर का लाइन चेंज करना है. Though the OP number 1, though the present applicant, present respondent insurance company filed written statement, however, later on he failed to pursue the matter, and the claim proceeding proceeded ex parte against it. उसके बाद ये issues thereafter A from page 12 of the memo of appeal. How many witnesses were examined by you?
As many, only one, but 3 court witnesses was examined.
The present appellant examined himself as a witness in the claims proceeding. However, the court also examined 3 court witnesses in the aforesaid case. Ultimately, by the judgment and award which has been impugned in this appeal, all the issues were decided in favor of the present appellant, and the claim case was disposed of by directing the insurance company to pay a compensation amount of rupees 8,75,000 to the present appellant, along with an interest at the rate of 7% per annum. So, Mr. M. Talukdar, learned counsel for the appellant, has submitted that the tribunal has erred in computing the compensation which was granted to the present appellant. He submits that though the court witness 1 and court witness 2 in their testimony before the claims tribunal have categorically stated that the present appellant was a driver.
CW1 and CW3.
CW1 and CW3
CW3 IO.
driver, and though the claimant himself, the appellant himself, while deposing as PW1, has deposed that his annual income was 12,000 rupees at the time when the accident occurred. However, the tribunal erroneously took the monthly income of the appellant at rupees 5,000, which is much below than what he was actually earning at that point of time. Learned counsel for the appellant has submitted that a driver may be regarded as a skilled worker, and he may and his monthly income may be considered at least at rupees 10,000. You'll be producing some judgment in
That one is judgment is there.
10,000. He also submits that the since the appellant suffered amputation from shoulder level and he was assessed to have permanent disability to the extent of 85%. He should have been paid how much compensation against pain and suffering? At least 2 lakhs against the head pain and suffering. However, nothing has been granted to the petitioner against the head pain and suffering.
Sorry, Lordship. 50,000 each added for pain, sufferings, and agony undergone by the plaintiff.
How much only?
50,000.
50,000 was granted to the claimant against the head pain and suffering. He also submits that since this was a case of an injury arising out of a motor vehicle accident, no deduction on the under the head personal expense should have been made. However, the tribunal, however, he submits that the tribunal committed error by deducting 50% of the total income assessed. This deduction has been made under what head? It is not
Those are for personal and living expenses. Paragraph 14, page
under head towards
personal and
personal and living expenses. He also submits that since which hand was imputed?
right hand.
Since
Shoulder joint.
right hand of the claim applicant was imputed at shoulder level, and since there is a possibility of implanting artificial limb, and the appellant has also adduced evidence showing the expenses which may be incurred for implanting the artificial limb.
Exhibit 25.
Within bracket exhibit 25.
Estimate is 5 lakhs,
In-
4,020.
And the said estimate is to the tune of rupees 5 lakh 4,025.
250.
250. However, he submits that the tribunal has assessed the compensation under said head by granting a
3 lakhs only.
lump sum amount of 3 lakhs only.
Future expenses or future expenses.
What else?
Lordship, loss of amenities of life and loss of expectation of life.
Further submits that no compensation has been granted against loss of amenities of life and loss of future expectation. What is the exact head?
I think at least 1 lakh each maybe.
And he may be granted compensation against the said head also.
And for attendance charges, no amount has been given. He was in the hospital for as indoor patient 21 days.
He further submits that you have mentioned in your memo of appeal.
It is as a whole, it has been mentioned.
Where?
Paragraph 9, ground number 9. For the amount awarded in respect of pecuniary damages as in lower is in lower.
He also submits that though the appellant was admitted in hospital for indoor treatment for a period of 21 days, no compensation was awarded to him for against the expenses incurred by him for attendant towards towards his attendant. He also submits that the interest award
Special die.
You have not mentioned
Lordship. Okay, Lordship.
he has also submitted that the interest awarded at the rate of 6% per annum is also on the lower side, and same shall be enhanced. Same may be enhanced to at least 9% per annum. So, on the other hand, Mr. R. Goswami has submitted that the appellant has not adduced any evidence regarding his income. He submits that apart from production of driving license, no other document was produced to show the income of the appellant. He submits that the tribunal has correctly assessed the monthly income of the appellant at rupees 5,000, which is on a higher side than the notional income of unskilled worker, which was prevalent at that point of time. In support of his submission, learned counsel for the respondent insurance company has produced a notification dated 15th March. Upper learned counsel for the appellant has cited following rulings in support of his submissions 1, 2, 3, 4, 5.
May I add something? Since he has brought in something after the.
Let me first
Yes.
record what.
It may be mentioned that the insurance company has not filed any cross appeal or cross objection.
Yes. Muslim Calligraph. Notification dated 15th March 2012, which shows that the notional income of an unskilled worker at that point of time was only rupees 3,000.
130 into 30 lakhs.
3,000 not?
3,900 because part
Okay.
8 is shown as 130.
3,900. He, however, fairly submits that since the case is a case of injury in a vehicular accident, no deduction ought to have been made against personal and living expenses of the appellant. He also submits that the tribunal has also rightly assessed the lump sum amount towards future expenses, which take care of the necessity of implanting a artificial limb in place of the amputed right hand of the appellant. He, however, submits that no interest can be granted on the future expenses, on the compensation awarded against future expenses by the Motor Accident Claims Tribunal. He submits that as the said expenses was not incurred by the appellant at the time of the accident and it was only a future contingency, no interest can be awarded on such a future expenses. Yes, what you want to say?
Look, also mentioned about this loss of amenities and expectation lordship. I'll just read out one paragraph from a judgment lordship has very often. It's Rajkumar versus Ajay Kumar. It says one thing, paragraph 15. It may be noted that when compensation is awarded by treating the loss of future earning capacity as 100% or bracketed in bracket or even anything more than 50%, the need to award compensation separately under the head of loss of amenities or loss of expectation of life may disappear. And as a result, only a token or nominal amount may have to be awarded under these two heads.
Lordship, there are.
Let him complete.
So this is what this can be maybe at best a token nominal, because once it is 50% or 100% is given, the need to appear, the need to award compensation separately under the head of loss of amenities or loss of expectation of life may disappear. So this is one submission also. And regarding that, I'm submitting this judgment of Rajkumar versus Ajay Kumar also. That's that 85% means there also somebody said he has claimed it as 100%, but even as
Give that to me by marking.
I marked it also.
Wait.
So para 20 and para 15. Para 20 for illustration B. And also, this judgment to substantiate is that no interest need to be granted under future expenses. This RD is a very famous case, RD Hatangari. For all injury cases, this is the case that is mostly relied upon. RD Hatangari versus pest control of it. There are 15 and 20. Let's have 15 at the top. The next one is RD Hatangari lordship. It's a case of an advocate who had suffered paraplegia.
Learned counsel for the learned counsel for the insurance company also submits that when compensation is awarded by treating the loss of future earning capacity at anything more than 50%, the need of awarding a compensation separately under the head loss of amenities or loss of expectation of life may disappear, and only a nominal amount may be awarded under the said head. In support of his submission, he has cited the ruling of the apex court in the case of Rajkumar versus Ajay Kumar and others, reported in 2011 1 SCC 343. He has also cited a ruling of the apex court in the case of R.D. Hattangadi versus pest control. This you are relying for?
But no interest need to be paid for future expenditures.
Okay. Pest control within bracket India Private Limited and others. So
Small final submission. That's it. This appeal was filed in the year 2017. And it has not been pursued, lordship. It has been changed. So that while considering interest, lordship, this part may also be maybe 9% or actually 6% for the whole period. or if this interest may not be allowed for this part. They have simply failed to pursue. Only one day, this case has been listed.
Before this court,
I think it is 2017. This Okalum was filed. After that,
then in the event of delay in disposal, you have to pay the interest. Therefore, you have to pursue.
consider the length of the interest. Interest may be considered 6%. Consider length, it will be 100%. What about a compensation?
The claimant side is very diligent, Lordship.
I have considered the submissions made by learned counsel for both sides and have gone through the materials available.
Lordship, I
No. Now, if you have anything, give written submissions.
Lordship, I will submit some citation.
Give in writing. क्या लिखा?
That only interest rate Lordship may. It will become 100% anyway, Lordship.
I have also gone through the records of the MEC case, which was requisition from the concerned motor accident claims tribunal. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submission. You may submit the ruling. Mention on the left-hand side that this is by appellant. Write as appellant and then mark the paragraphs which you are reading.
Lordship, I will submit it.
Lord so and so. Hearing concluded, judgment reserved. Meeting. Remaining matters will be left over. If anybody has any urgency, they can, wait. They may take dates from the court master according